10 days. We're trying to run down the public defender. He was here and he left. Let's talk about these cases. I thought we had taken care of everything that you had when I saw you the last time. And then these two popped up somewhere and they need to be addressed.
I thought I had some no vacancy. I'd been written a couple of no vacancy tickets from an officer over there.
Yes. Oh, and of course you're not in my queue. Give me a minute. I'm waiting for the public defender to rejoin us.
Yeah. Can I just go ahead and waive that?
Yes, I think we'll get to it here. I'm not sure why these aren't in my queue, but I'll get them.
They also have some. One or two cells.
That room is so noisy. We've had a long morning here. I thought it would go smoothly, and I guess it went smoothly enough. You've got two white pigeon ordinance cases of disorderly person. Well, let's talk about those. File 251904. I wish these were in my queue. It'd make life a lot easier. You got a ticket for being a disorderly person. I guess this is Three Rivers. Found loitering behind the Shell gas station. We already did that one. Yeah, that one's done. 1904. 1904.
But he was probably be able to manage, but like if we had set up, like he would be able to be
All right, in that one, it is alleged that you were a Chicago Road near the railroad tracks and you were a vagrant and they allege prowling. That's White Pigeon Village Ordinance that allegedly occurred at 12:30 in the morning on September 19th. That's a misdemeanor. Punishable by up to 90 days in jail and a fine of up to $500. The prosecutor is recommending that if you just plead to both of these, they would recommend time served and fines and costs, and you've been in jail for 10 days. That's the September 13th case. The other one is 1599. It'd be easier, like I said, if these are in my queue. I don't know if I deleted them or they didn't get in here. The other one is alleged to have occurred on August 3rd, prowling around property without knowledge or consent of owner, West 420 West Chicago at Miller Drive. So essentially, the allegation is that on September 13th and October 5th, that you were homeless, and it violates the vagrancy prowling ordinance in White Pigeon. I had represented to you the last time, and I would here, that I would give you a sentence of time served and the minimum allowable fine. You understand the charge?
Yes, sir, Your Honor.
Is that what you wish to do?
Yes, Your Honor.
I would have taken care of these the other day when I saw you, but I didn't. I didn't have them, or I didn't know what the deal was. Now, as I indicated, the public defender isn't here. He walked out and we haven't been able to find him. I can wait until the public defender is available to assist with this. And you told me you simply wish to waive that and get on with this plea and sentence.
Yes, sir, Your Honor.
All right. Other than what I told you here, did anybody promise you anything to get you to plead to this
Sir. No, Your Honor.
or threaten you?
No.
Do you understand that if you plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes. Yes, Your Honor.
We just did this the other day, but if there was a trial, you'd have the right to be represented by an attorney. All you got to do is ask me, and I would appoint an attorney for you, and all you got to do is ask me, and I'll wait to find the public defender. Do you understand?
Yes.
If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. All right, let's talk about the first incident. It was about 8:20 at night, so it's still light out on August 3rd, for Chicago Road and Miller Drive. Where was that?
We see an old Mexican restaurant over there across the street from the laundromat. It's condemned now.
All right, you were hanging around behind there.
Yeah, I stopped there to take a break. I was coming from Sturgis to White Pigeon to see my brother.
Had you been drinking?
Yes, a little bit, Your Honor.
All right. $10 days, credit 10 days, leaving 0 days to serve. Concurrent with the other case, which is 251904. $125 or 2 additional days. Do you have an out date yet?
No, Your Honor, I do not.
Well, these will be 2 less things you have to worry about.
Yes, sir.
Let's talk about the other ticket. That one was late at night on September 13th. And that was, I forgot where that one was. By the railroad tracks. Again, you were basically homeless. Were you at 12:30 at night hanging out on the railroad tracks?
Yes, sir, Your Honor.
Had you been drinking that night too?
No, sir.
How'd you end up in White Pigeon, on that night?
I had some stuff. Visiting with my brother. I live with him, but I stay with him sometimes. I was just there picking up my belongings from there.
All right, same thing, 10 days credit, 10 days. I'm going to give you the minimum allowable fine of $125 or 2 days concurrent with the other case. Let me see what else you got holding you in there, Mr. Brooks.
Yes, sir.
Well, you got a circuit court case with Judge Stutzman. Yeah, you failed to appear. You have a trial date, like imminent. Is that case coming up soon?
Yes, sir, Your Honor. It's November 14th, 17th, I
All
believe.
right, well, I hope that matter is resolved. All right, you're good to go. Thank you.
Thank you. Thank you, Your Honor.
Good morning. Did you ever get connected to Mr. Gibson?
Yes, sir, I did.
All right, well, whatever's going on, will be going on in Judge Patterson's courtroom.
Okay,
So,
thank you.
all right. All right, he waived the public defender and we just got rid of 2 cases and that's probably sufficient. All right, we're gonna.
And we will, so there's no opportunity for this to be resolved, it looks like, right? No,
No, I'm sorry, Your Honor.
that's all right. Let's set a jury trial. And we'll set a final pre-trial. Unless it's just a complete waste of time. Ms. Alloway, your name?
Good morning, Your Honor.
So I'm gonna set a jury trial in this matter. He wants a jury trial, the defendant does, I should say. They had a final pre-trial. Unless you guys just tell me, Judge, it's gonna be fruitless. I could care. I don't want to drag people in here just for no purpose.
Your Honor, I believe it would be fruitless, but some miracle arose and we resolved it. We contacted employee immediately.
All right.
The offer I gave is the final plea offer, so it's,
Okay.
Mr. Carlos, if it's fruitless or not.
What's the plea offer? 769? Okay, good enough. So why don't you give me a jury trial date out about a month? Heather,
Okay,
I want to make sure it's good with the lawyers here. Are you guys good? Let me just start like this. Are you guys good on November the 14th?
Your Honor, I am not available that day. I have another trial on Taylor.
I had a jury trial in Taylor too.
Oh, wait, that's
Jack
not.
Farmer.
Okay,
Sometimes known as Farmer Jack.
how about the 21st?
Let's see, the 20th of November,
21st.
I'm in, check off the judge, I'm up, Genesee County.
Your Honor, does this court do jury trials on Tuesdays?
I can't do that with the press. I just can't.
What?
The 21st is a Tuesday.
21st? No,
Friday.
No, wait.
no, November 21st.
Yeah, October.
That's okay.
Okay, the 21st I am available.
It's not gonna be good. It's not, I mean, I'd love to have a trial, but it's not gonna be good that night.
I'm available the 28th. There's a,
It's the day after Thanksgiving. My staff would appreciate coming in. Okay, I do gotta move this along though. December 5th is the latest I can go, or else I gotta start working on another day.
December fifth.
Did you say December fifth?
Yes,
That says Judge McNally all over it. Yeah.
you could,
That works for me.
okay. Now, you guys, I'm gonna set the jury for 12-5 at 8:30. And here's what I'm gonna need. Now, Ms. Alloway, you know, you're probably not aware of this, but a few years ago, they made us start publishing books to the jury. You might be aware of that, but they didn't make us do that until about 6 years ago, I'm guessing. I don't know, could be 10, but at any rate, I don't want just numbers. I want you guys to prepare jury instructions that you both agree upon. If you don't agree upon something, we can make a note and I'll decide. But can you prepare a set of jury instructions that have everything typed out? In other words, the prosecutor's name is Ms. Alloway. The defense lawyer's name is Mr. Colovas. The defendant is with everything.
I have a problem. I have one already.
Okay, can you guys submit jury instructions by, this should give you plenty of time, but don't make me bug you, okay? Submit jury instructions by November 21. Can you do that?
Sure.
All right. And then we'll start promptly at 8:30. If somehow there's a plea, the only thing I ask, or a dismissal, I just ask that you guys notify us and put it on the record so we don't have to summon 25 jurors in here. And I can at least call them 2 nights before and say, hey, you don't have to come in. Fair enough?
It's fair, Judge. You have a pleasant day today.
You too. Thanks a lot. We'll see you back here then. Thank you all. Thanks, Mr. Grimes. So you got that date, correct, sir? Mr. Grimes?
Yes, sir. I'm sorry about that. A little technical difficulty.
That's
Yes.
okay. December 5th. Thank you.
Thank you. You have a good day.
You too. Do I have anything else down there?
Judge, I have this Michael Nelson here, but this is the only one we don't have an attorney for, and I called for a spot appointed this morning, but we yet to have one assigned to him yet.
There was not one assigned before?
No, this was the only one that Lisa left me a note on that the assignment wasn't accepted yet, and it still was not as of this morning when I spoke with them. And they were trying to get someone when I called first thing this morning.
All right, if you don't hear in about 10 minutes, will you let me know, please? And I'll make a call to Ms. McRipley.
Okay,
Thank you very much, Heather.
you're welcome.
All right, well, all right. Let us know when we have something, whatever. Thank you.
Okay, Judge. Samsung user, can I get your name, please?
Thanks.
Do you? Oh,
We
Heather
just
does?
found it. Jen Wiseman just found it, Judge.
Okay.
Thank you so much. Oh, well, actually, so we have this one.
He's actually sure, but
You can run and do it.
I just want to make sure. Okay.
There's another one right here.
Okay. If you want to hand that up, we'll call
Nice
it.
job, Judge. I love him.
How you doing today?
Good job. Good to see you all.
Chip.
Oh, sorry.
Oh, two.
Hello,
Your name?
Dominic Gallo.
All right, I'm gonna adjourn it 1 week, okay? So you go ahead and take care of whatever you guys talked about. October 21st, we can make this at 8:30, right? Heather?
Yes, Judge.
October 21 at 8:30, okay? So get whatever you need to have taken care of, and we'll see you next
So-
week.
So all he wanted me to do is bring the receipts that show the repair, and then he actually wanted me to bring the whole semi truck down there, which I didn't recommend. You guys wanted me to put a semi truck in your parking lot, but then you said just to take a picture of the tires. So-
Hey, whatever you guys
So it's
talked about is fine
October?
with me. I don't care. I don't need to have well, you're gonna have to figure out a way to provide him with whatever proof he needs. I don't have anything to do with that. I don't want a semi truck in the parking
All
lot.
right, yeah, I tried to show him the receipts. We did the repairs, but he said he couldn't see them through the phone.
So maybe you prepare him and email him over here, or call him or send him over here so he can see them, right? I
Okay,
don't know.
he didn't say that to me, but I can do that.
I don't want to get
Is
in
there
the
an
middle
email
of what
address
you
I can
guys,
send
I
it
don't
to?
get in the middle of what they got, those guys do back there. I try not to. It's not my function, you know? I mean, I don't know what else to tell you.
Okay.
Okay, so you
I
can
just don't want to
talk to
waste your
him.
time anymore, but
You're not wasting my time. But I'm not, I don't do their plea bargains. Whatever's gonna make them happy is good, right? I mean, so that's it. All right, thank you. Good luck.
okay.
Malik, Noah, Yusuf.
So October 21st, 8:30?
Correct.
Okay.
25W72353.
Am I all set?
Good luck, sir. You're all set. Thank you.
John
Okay,
Hudson,
bye.
on behalf of Malik Yosef, East Milo, please identify yourself. Good morning, Honor. Noah Yusuf.
Are you moving to dismiss this?
People cannot proceed at this time.
Well, I'm not dismissing these cases, guys. I don't know what this sudden. I don't know why they think the judge should be the one dismissing the case. Listen. You're telling me the complainant won't proceed. I'm either setting it for trial, in which case jeopardy will attach, or you guys can move to dismiss. I don't know what's going on over there. What? Did somebody tell them? Hang on. Did somebody tell them they're dismissing too many cases or something? I mean, what in the world is going on? I'm not dismissing a case because you're telling me the complaining witness won't. If you want to move to dismiss, you move to dismiss. If you don't, I'll set it for trial. I don't get what's going on out there. I just don't understand it. Everything's so that's it. I'm not dismissing.
Originally, we said it for 2 to 3 weeks.
That's between you guys. I'm not dismissing it. Case dismissed, motion to prosecute. I mean, I don't know how they expect me to dismiss these cases. I don't know whether the complaint witness is or isn't. That's it. Case dismissed.
Thank you, Judge.
Janice Arnold, 24W834741 A and B.
Good morning, Your Honor. Christopher Semke, appearing on behalf of my client for arraignment. She's, I believe, in lockup.
Is she in lockup here?
Yes, Your Honor.
This is about 33rd. You guys said 2 in custody.
Is it, oh, she's in lockup at Woodhaven is what you're saying?
No, she's in the building, Judge. I spoke to her. She's in the back.
I don't know what to say.
That's not safe.
Yeah, Louis Miller. He's in custody.
I'm not blaming you, Ms. Alloway. I want to be clear.
Yeah, it was,
I don't,
yeah, he was gonna dismiss it.
it doesn't matter. I can't, I'm not this, if it was a trial date and the victim wasn't here, that might be a different story, but not really. And then you want to get out, Arnold, Janice Arnold. All right. People against Janice Arnold. 24W8347418 and B.
Good
All
morning.
right.
Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom as the arraignment. We waive formal reading. My client stands mute.
All right, I gotta wait for her to be pulled out. I shouldn't have called the case so early. My apologies.
No
You
issue.
got a 2024 no proof. You got a 2024 drive while suspend. Ma'am, your name?
Janice.
All right, so you can repeat what you just said, Mr. Shemke. Your client stands mute, waives formal reading.
Yes, Your Honor.
Not guilty, pleas are entered. Where's she been? Why didn't she show up?
Your Honor, she's apologetic. I think she's not on probation parole. I think that there was some confusion regarding actually having to come to court and maybe just thinking it was a civil infraction. She's 62. She's retired grandmother, lives with her 35-year-old daughter. She understands, and she's already dealt with, obviously, the complications of being arrested this morning. I asked for personal bond and a court date.
Ma'am, why don't you stand up for me, please? Why weren't you here when you were supposed to be here? This was a May of 24 incident. You didn't show up in June of 24 and you didn't show up in July of 24. We sent you 2 invitations, birthday notices, so to speak. Well, the only one we got is the one that's on your citation. That's 12335 Monica in Detroit. Were you there in 24?
No.
Why didn't you change your address with the Secretary of State?
Been doing that, but
Didn't do it yet?
no, I still haven't did it yet, but I didn't get any of those citations. But when they had,
You gave the officer, ma'am, listen to me very carefully. You gave the officer gave you a citation.
yes,
Did he bother calling the court on the bottom there and saying, hey, I got a ticket. I don't know what happened here. Did you bother doing that? Why not?
I don't know, but the first time that I had got, stopped by the police, I had my license. That's not, it's me, but it was my daughter case. I had been paying that case when I was working. They were garnishing my wages. Now, she had got arrested for drinking and driving. The problem was, the car was in my name, but it was her car. But they had put all those charges on me as if I was the
I
person.
think you were driving on a suspended.
No, this time I was, the first time I was driving on suspension, the day that they pulled me over, that was my first day of me knowing that I was suspended. Period.
Okay, so what does that have to do with anything? You still got to set a court date. Why didn't you call the court and say, hey, listen, what happened with this?
I didn't do it. but
Well,
I didn't do it. And that's my fault.
do you work?
No, I didn't, I'm retired.
You collect a pension?
Yeah,
From where?
Fort Road Company for my husband.
You're gonna have to post a bond today. You have a credit card with some money on it? Or cash?
They sending me out one. I got $96. I was just taking my grandson to school because he was running late. I got $90-something. That's all I have.
All right. $96 cash bond. Okay. Gotta show up in court though. Give me a court date, Heather.
Is
This
there
is-
one, is
this
there
is
one on the
actu-
front of there, Judge?
Oh, I'm sorry. This is actually in front. Is this in front of Judge Hessen or me?
That one would be a Judge Hessen case.
Yeah, so we're gonna give you October 22nd at 11 a.m., okay? And then Well, I can give you November 5th, actually. I'll give you November 5th, all right? November the 5th at 9 AM, and you should clear up everything to make sure you have a valid license when you come back, okay? Gotta show up in court, right? Yes, ma'am. But you're gonna be in the courtroom next door. You're in front of Judge Hessen, right? Wish you well. Good luck. She'll take you out, post your $96 cash bond, and you're all set. Thank you.
Thank you, Judge.
Kenneth Noel Gibbons Jr., 25M95595476. All right. Where is Mr. Gibbons?
He's
Give me
coming
some-
in, he's coming
Okay.
in right now, Judge.
Yeah.
Your name, sir? You have to unmute and tell me your name, sir.
Kenneth Gibbons.
All right, Mr. Gibbons, congratulations, you're a winner. I gave him 15 minutes. He was scheduled for 10. It's 10:22. The officer failed to appear. Case dismissed. Good luck to you. You're all set.
Everything's good and no charge?
No charge, no points, no fine, no nothing. What a great system, huh?
Man, I love it.
Good luck.
Thank you very
Scott
much. Have a good
Tackett.
day.
You too. Thanks a lot. Scott Luke Tackett. It's Mr. I need Mr. Baziani on this. How about John Rods? John Raymond Rads Jr., 25M595026.
He's coming in right now on Zoom.
Mistake. I put that one aside. Sir, your name, Mr. Rads? You just have to start your video and tell me your name and unmute, please.
Am I unmuted yet?
No, you're great. Your name?
John Rads.
I'm sorry, I got all these files up here and I put this aside. My sincere apologies. We gave
Oh,
the
no worries.
officer 15 minutes. It was scheduled for 9:45. It's 10:24. You're all set. Case dismissed.
Oh, well,
Good luck.
thank you, sir.
You're welcome. Is Mr. Graziani in here yet? What's his number there? 271.
Am I good to hang up, sir? I want to make sure I'm not missing
Oh,
anything.
yeah, you're a winner. You're a
Have a
winner.
great day. Have a great day. Thank you,
And
sir.
if you would, Mr. Graziani, real quick, please.
Okay, sure, Judge.
Thank you. All right, people against Scott Luke Tackett. Scott Luke Tackett, 199-714-701. Heather,
Yes, Judge?
we're gonna issue a show cause versus the surety company. As to why they shouldn't be required. Lisa knows, so if you can put this file on your desk. Mr. Graziani, your appearance?
For the record, John Graziani, P number 43387.
So this guy, I don't know if he was brought in. It seems like he was. This is a 2019 case. I said 3,010%. He didn't appear. He posted a surety bond. So I'm not going to play games with him anymore. We're going to show cause the surety company. I'm going to forfeit the bond. 15,000, 10% will be the new bond on Mr. Tackett. Thank you very much. Thank you. People against Peak. Nicholas Philip Peak, 23T727397, 23B144572. Your name?
Nicholas P.
Did you just walk in today?
Yes, sir.
Have you talked to a lawyer?
No, sir.
Mr. Shemke? Can you handle this one, Mr. Peak?
Absolutely.
yeah.
Just direct him
Come
to
on in if
head
you
out of
would.
courtroom. I'll be right out.
I'll hand you these files. I'll put them right on the end here.
Thank
You
you.
can have a seat. Mr. Shemke there will be the one talking to you. Okay?
Thank you.
Miller, Louis Jerome Miller Jr., 24W7216113FY.
He's in lockup.
Okay. All right.
That's what.
Well, can you get out or have John get out Mr. Miller, Louis Miller out of lockup, please? Louis Miller.
Right now, sir.
Thank you.
Okay.
All right, Mr. Woolak, come on up here. We'll wait for him. How you doing?
Doing good. How are you?
Real good. So just gonna work out for him, huh?
Yes.
Was this Mr. Mohammed that looked at this or Ms. Elway?
Mr. Juan.
Okay. And he's moving an alley cross, right?
Correct.
In the interest of justice. He doesn't think he can prove his case, huh?
Well, what happened, because there's two co-defendants, if you heard the exam and dismissed the case, I don't think you can move it against yourself today, so.
Not usually. Yeah, I did hear this one. Where was this at?
This was the burglary tools in the vehicle, it was a key fob.
Oh, yeah. I remember that. And they didn't appeal. I think they were gonna appeal me.
I don't think they did.
No, I don't think they did either. I would have known about it. So we'll get him out. Sorry to carry on like this. You coming out of lockup, sir? Just kidding. Is he?
Yeah, keep him busy.
No, I could probably. Heather, did we already give that one file away? Good morning, Mr. Miller. Your name? You didn't show up. Why didn't you show up on this case?
Oh, show today, I believe.
Oh, you didn't show up initially. You didn't show up initially, right?
No, I had my probable cause.
Okay, I don't know what happened here. Anyway, maybe, I don't know what happened, but at any rate.
Is Kevin Saylor. Case number is 25CR42759. Mr. Saylor is present with his counsel, James Staten. The state is represented by Teresa Hyatt. We are here, first of all, for regarding a report on competency. Have you had a chance to discuss this with Mr. Saylor?
I have, Your Honor.
Mr. Saylor, tell me what you think is happening today, sir.
Taking a plea of, like, I still don't understand the plea because it didn't happen that way. I didn't use force because when I walked by her car, she caught my eye because she was wearing bra, bikini top and bottom. And I opened up the door, touched her butt, but I didn't put on her shorts or put my hands up under her shorts. But I take the plea if it get me out of here faster. They could say whatever they want to, as long as I know the truth. Because my biggest thing is drugs. I love drugs and I love my gun. When my gun got taken away in Kentucky, I lost my mind.
Okay, sounds like you're saying you understand what you're doing. You understand that you're pleading guilty to a felony sex offense involving force. Do you understand that?
Basically, kinda.
Okay, it sounds like you were denying the force part there to me. Do you understand that you're pleading guilty to a 4th-degree felony, which will be with you for the rest of your life, and you'll be required to register as a sex offender for how long on this?
15.
It's at tier 1, up to 15 years. Your Honor.
Okay, could be 10, could be 15, but it's up to 15 years.
Whatever, to like give back home to my family, whatever to see my family case. My mom and my dad loves me, and I got to be there for them because they getting old.
Okay, here's what I need to make sure of, is that you understand what you're doing.
Not really,
Okay,
because sometimes I black out and I don't know what I'm doing. Like I didn't even know what I did until they told me when I got to the jail that day. And it
Okay.
was on my brother's birthday.
he's trying to see if you know what you're doing today as far as taking a plea instead of sitting in the toilet.
Okay, yeah, I understand what's going on today.
Tell me what's going on today.
Taking a plea instead of taking it to trial.
Right, that's right. And that means you admit to doing this.
Yes,
Okay, and you admit to not only touching, which would be sexual imposition, you admit to touching by force, which is gross sexual imposition.
I didn't admit to that, but I admit to the other one. They could say that to get me out of here today.
Well, we can have a trial too. You
I don't
can-
want to have a trial because it'd be less time and more time in the jail.
Not necessarily. You could go to prison for 18 months on this charge. If you're found guilty of this charge, you could go to prison for 18 months. Do you understand that?
Yes, sir.
Okay.
Do my jail time counts too?
Yeah, your jail time counts too, but I want to make sure you understand that you could go to jail, you could go to prison for 18 months and you're pleading guilty to something that you say you didn't do. So there's a little bit of a discrepancy there. Now, if you've talked to your attorney and you feel that the act you committed was done with force, then you understand what's going on. But if you're standing here and denying any force to me, I have a problem with that.
Yes, sir.
Yes, what? You understand what I'm saying?
I basically understand what you're saying in some kind of way, but in other ways, I don't really know what's going on because I ain't on the right meds like I'm supposed to be on. And when I was a kid, they put me in foster care, and I got raped by full-grown men and full-grown women when I was a kid.
Okay. That's a traumatic experience that I assume you discussed with the people who at Summit who evaluated you.
I want to talk about that to them because they asked if my people, somebody in my family commit suicide, and I stopped talking to them. I stopped seeing that lady, Cammy, and she came in, done another person came and done another interview, and I didn't understand. They just asked if we knew something about trial and stuff. But the first doctor, Dr. O'Donnell, was asking me if I had anybody in my family commit suicide and stuff. Yes, but I didn't tell her that. And when I don't get my way or whatever, if you look at my arms, you can see I'm a big cutter.
Okay. Mr. Statement, why is he pleading guilty to this offense?
Your Honor, my client is adamant that he does not want to go to trial in this matter. And that's the discussion we've been having.
But
is,
he's denying
the force aspect, yes.
Okay.
And my recommendation would be set it for a bench trial.
Well, this doesn't appear to be your
But
recommendation.
my client is adamant he does not want to go to trial. He wants to accept a plea.
is that right?
Yes, so to get up out of here and get a treatment program, because I am very addicted to drugs.
Okay, okay. Pleading guilty to something doesn't guarantee you'll get a treatment program. I'm more hung up on this fact that you deny that there was force involved. Now, if you have a trial and it turns out that it was, you're not going to be punished more just because you had a trial. If you plead guilty and you're saying, I accept the responsibility, I did this, I did it by force, which makes it a felony, that's fine too. But you're saying two different things. You're saying, I touched her, I didn't use any force, and I just want to get this over with. But that's not going to get it because you're going to regret it in the future. If that's the case.
I take it to trial then,
Okay.
because I still don't understand what's going on.
Okay, well, you seem to have a good understanding of what's going on. The problem is you're saying some things that are contradictory, meaning you're saying one thing and then you're saying another. That's the exact opposite. So set it for trial. Very good. Bench trial.
Hold on, but we still have the competency issue. Are we stipulating to the
I'm
competency
sorry, I kinda
report?
skipped-
I thought, yeah, I just want to make sure
Yeah.
we've done that first.
Okay, let's talk about that. You have been determined to be competent to stand trial, meaning you understand the charges against you and you understand enough to assist your attorney in defending you in this case. You had two choices. You can agree, yes, I'm competent, or you can say, no, I'm not, and your attorney can request a second opinion. The second opinion may very well say the same thing because you seem to understand what you're doing. Your attorney is saying, we agree Mr. Saylor is competent. He understands what's going on and he understands enough to help me defend him. Do you understand that?
Yes, Your Honor.
Okay. Do you believe that's true?
Yes.
Okay. Then I'm going to make a finding that he's competent based upon Dr. Nick Stein's report. She's a very qualified psychologist, and she's made a determination that you've been at Summit long enough. They helped you understand how to participate in a trial. So we're going to go to trial in the case, and I don't know what the outcome will be, but it's not going to be any worse. You're not going to be punished for exercising your right to have a trial.
And my jail time accounts into my sentencing too?
You already asked me that. Do you remember asking me that a few minutes ago?
No.
Okay. Yes. Yeah, for all the time that you serve in jail on this case, you get credit for that. If you're found guilty and you're sentenced, you'll get credit for that as a part of the sentence.
Either way, if I take it to trial, take a plea, it's 18 months. I got to spend.
That's the maximum you could get. It doesn't mean you'll get 18 months. I just want to make sure you understand you could get 18 months. Either way. Do you understand that?
Oh, yes, so I don't really want this on my record because I got enough felonies on my record, and I don't want this on my record.
Okay, well, I don't blame you. If you're found guilty, it will be on your record. And if you're found not guilty, it won't be on your record.
Because Kentucky, they dismissed a handgun case, and can Kentucky pick up my handgun case and send me back over to Kentucky? Because I would have spent my jail time in Kentucky. At least I could smoke in jail, the vapes.
You know why you can smoke in jail in Kentucky? Because tobacco is their main crop. Okay.
Hell, a pot is that us main crop.
Well, it may be.
I'm a
But
big pothead.
I can't advise you on Kentucky. If they dismiss the charge, it's dismissed. That's where it stands. I can't predict the future. And this trial is not going to affect what they do, to my knowledge.
Okay.
Ms. Hyatt, how many witnesses do you have?
I will have approximately, let me get to that, I'm sorry.
Did you say 4?
I would say 3 to 4.
Okay.
I don't anticipate any for the defense, Your Honor.
Okay. All right. So this is a 1-day trial at the most, maybe a half day.
Mhm.
Okay.
My mom and my dad was there. They was calling my name, but they didn't know where I was at. They thought I was in the bushes taking a shit. But I went to the bathroom at the store.
Are we waiving jury, Your Honor?
Or
we have the jury trial?
We've got to do that. There's 2 types of trials you can have. One is a trial to me. The other is a trial to a jury of 12 people. You have a right to have either. If you have a jury trial, all 12 people on that jury have to agree you've been proven guilty beyond a reasonable doubt. All 12 people have to decide that before you can be convicted. If you have a trial to the judge, it's just one person who makes that decision. In this case, that would be me. So if you want a jury trial, you can have a jury trial too.
I take a bench trial.
Okay.
I don't got no clothes what I could wear to a trial.
Oh, you can have clothes. We can get you clothes. Mr. Staten, have you talked to him about the difference in a jury trial?
We did, Your Honor, briefly, but as I said, he was adamant he did not at that time want to do a trial of either type.
Okay, why don't you talk to him a few minutes back there?
If I could.
He may be better off with the jury. I don't know, but at least
Sure.
I want him to understand the difference.
Absolutely.
Okay, thank you.
We likewise do not believe there's any conflict in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflict so that this honorable court could hear these matters.
And the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, People's State of Michigan versus Dustin Duncan.
Ready and then ready.
Kenneth Overwater, Assistant Prosecuting Attorney. People.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Duncan, who approaches the podium. Mr. Duncan, please state your name for the record.
Dustin Duncan.
Thank you.
Your Honor, Mr. Brown is ready to proceed. The people are not.
We would move for dismissal here.
People being unable to proceed. This case is dismissed on the defendant's motion. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the People versus Jamison Napier.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
And Wilson Tanner appearing with and on behalf of Jamison Napier. Your Honor, Mr. Napier we are ready to proceed with the preliminary exam. I understand, well.
Now, the prosecution would be moving to adjourn this matter for 2 reasons. First of all, I was informed late Friday that the victim in the case resides in Florida, so I would need to file a motion to allow him to appear by Zoom. This was the first I was made aware of that, but additionally,
But it isn't the first your office was made aware of.
I can only speak to what I was aware of, Your Honor. I understand.
Well, you got to speak to more than that, Mr. Overwater. If at the time that this was set, back on September 18th, quite frankly, that had to be, somebody had to know that, only because of and I can go back and find out, but because of the date that I set it for. Because normally this would have been set at the end of September. And there were an additional 2 weeks given for the preliminary examination.
I understand. Additionally, Your Honor, I would point out that there are 3 additional witnesses, defenses advised they would like us to talk to. One of the witnesses is mentioned in the police report, but he, according to the report, refused to speak to the officer. I'm told that now this person is willing to speak to us. Additionally, Mr. Tanner brought another witness who was not listed in the police report. I did have the opportunity to speak to him today. So I'd be asking to adjourn this matter so that the officer in charge can speak to these additional 3 witnesses that counsel wants us to talk to, so we can get a more clear view of what actually occurred that night.
I appreciate Mr. Overwater work in this case. I know he just got on the case, but this has been going on for a long time. Normally, I would agree to an adjournment. I think that this case should be dismissed at this time for them to do the investigation that the officers had available to them. While it's not listed in the police report, these additional witnesses, all of them were at least mentioned in the interview with the police officers. Some of them as didn't make it into the police report. I don't know why they didn't pursue it in the interview. They have the address certainly of at least 2 of the witnesses where the incident happened, and which happens to be.
You still want to keep going?
And no.
No, you can go ahead.
No, thank you.
No, really, I'm listening intently.
And I mean it. I don't. I asked that this case.
Defendant's motion to dismiss is granted. Case is dismissed without prejudice. They can reauthorize if that's what they want to do.
Thank you, Your Honor.
Thank you. Court calls the cases of the people versus Stephen Grisbeck.
Prosecuting attorney.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Grisbeck.
Kyle Riddle filling in for Attorney of Record Sam Bernstein on behalf of Mr. Grisbeck in the case ending in 1127 with Mr. Grisbeck's permission. Is that correct?
Yeah.
Thank you.
And your name?
Mr. Stephen Grisbeck.
I kind of know that we've seen each other over and over again. All right. What are we doing?
Your Honor, we have entered a waiver on all of these matters, and I'll let Mr. Upperwater put the offer on the record.
That is correct, Your Honor. Pursuant to that waiver, people will agree on case 25 F1 1127. Sorry, on the case number, the other FTD charge. He can plead in circuit court to a reduced charge of false pretenses 200 to 1,000. There is no offer currently with regard to the other case of possession of methamphetamine. However, if he chooses to apply for drug treatment court, the people would not oppose his application and would agree to reduce that matter to a use if he were to successfully complete that. If he chooses not to apply for drug treatment court, then that case can be further negotiated in circuit court. The people may consider a deferred prosecution on that matter pursuant to Mr. Grisbeck completing residential treatment. It is my understanding that he would be going to Sacred Heart in the next few days. So that's our primary hope, that he can get into treatment and get into the recovery program.
And that is our understanding of the offer, Your Honor.
That's correct, Judge. All right. So he's waiving, however.
Correct.
Mr. Grisbeck, is that correct? You're waiving preliminary examination?
Yep. Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution on all of this.
Yes, Your Honor.
All right. For the record, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court in the 3 cases on all 4 counts.
Acknowledge receipt of information, Your Honor. Waive formal reading, stand mute at this time.
Defendant, every waive formal reading, and you go ahead.
As well, Judge. And as to matter 1127, waive formal reading, stand mute.
Defendant, every waive formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in these matters will be set for
October 28th at 1:30 for Judge.
October 28, 2025, 1:30 before Judge Cook.
And if you're in recovery, I'm okay with it.
Bond will continue. He hasn't been, I know I signed orders of release, but they haven't gotten you the treatment yet.
I'm supposed to be leaving tomorrow.
Tomorrow?
Yep.
Good. Mr. Grisbeck, good luck to you.
Thank you, Your Honor.
Thank you, Judge.
May I approach sign information?
You won't get them to you in just a second. October 20, 2025.
Oh, nice.
It's 1:30. I don't know why I'm running 9 AM.
If you, yeah.
The other judges don't require. Yeah.
I wrote down what the misdemeanor. The one sent his plea form in this because his client's in custody. He's gonna sign this as he comes out.
Got it. He's got the plea form.
He's got the plea form. This is what.
Last night.
You want me to call for him? I didn't want to hurt you.
Yeah, no, go ahead. I'm sorry. Thank God they were all stapled. I would have preferred if they were loose and they just went everywhere. Oh. Court does call the case of the People's State of Michigan versus Jeremiah Sawyer.
Ready Judge Torshell Feaster, Assistant Public Defender on behalf of Mr. Sawyer, who is approaching the podium. Excited today.
I understand it's a plea, but I form it, yeah. That the defendant will be pleading no contest to an added count to malicious destruction of building. Less than 200, the 93-day offense upon a successful plea to that added count 3. Counts 1 and 2 would be. Is there an amended complaint?
Judge, we did have, yeah, sorry.
Yeah.
Sorry, Judge. You did, we're planning to file an amended complaint that this case gone preliminary examination. That being adding count 2 malicious destruction of building. Just adding count 2 malicious destruction of building for between $1,000 and $20,000. And we would actually have gone to preliminary examination, dismissed count 1 outright.
Okay, well, then we'll have to start this way. Mr. Feaster, you acknowledge receipt of the New information.
Yes, Your Honor.
All right. You waive its reading?
I do, Judge. I'm sorry.
And how does your client plead?
He stands mute on the arraignment, Your Honor.
Defendant having waived formal reading standing mute, court will enter not guilty plea as to count 2. All right, and now there's a plea agreement.
Yes, Judge.
In which the defendant would be pleading no contest to an added count 3 of malicious destruction of a building. A 93-day offense. Upon his successful plea, counts 1 and 2 would be dismissed.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the whole truth and nothing but the truth, so help you God?
Yes.
State your name.
Jeremiah Sawyer. All right. So Sawyer, it is this court's understanding that you're going to be pleading no contest to the charge of malicious destruction of a building under $200. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is damaged. If that's greater than $500, that becomes the maximum fine. You understand that? Yes, sir. All right. Do you understand what a no contest plea is? Yes, sir. Let me explain 2 things about it just to make sure that you understand. The first thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that? Yes, sir. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Yes, sir. All right. Basis for the no contest plea.
Civil liability, Your Honor.
All right. So, sir, to that charge, how do you plead? No contest. All right. You understand that by pleading no contest, you'll not have a trial of any kind. Yes, sir. You signed an advice of rights form, is that correct? Sir. Any question regarding any of those rights? No, sir. You'll see a copy on the podium. Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? Yes, sir. All right. Were you on probation or parole at the time of this? Yes, sir. All right. Was it probation you were on? Probation and parole. Both? Yes, sir. Okay, you understand your plea in this case could be considered a violation of your probation and a violation of your parole. You understand that? Yes, sir. All right. You understand that if it's considered a violation of your probation, that court could sentence you to the maximum allowable under that other charge, or charges. You understand that? Say it again. If it is considered a violation of your probation, the other court that you're on probation to could sentence you to the maximum that's allowable under the other charge or charges that you're on probation for. You understand that?
He's saying that whatever judge has your probation case, they can sentence you if they determine this is a violation. Like we talked about.
Okay. Yeah, yes, sir. You understand that? Yes, sir. All right. You understand with reference to your parole, if it's considered a violation of your parole, that you could be sent back to prison to do the remainder of your term. You understand that? Yes. What's the chances of that though? I don't know how to answer that. I don't know. I'm saying like this.
Like we talked about, it's up to your parole agent that you said you can contact with your agent and they had a plan for it.
Yeah, but is they gonna like from your experience, right? Is this like
he can't give you legal advice?
Huh?
He can't.
You mean my experience on the bench or my experience with parole? Like from your experience, which one you trying to dealing with parole? Something on me? I don't. Go ahead. What? From your experience from dealing with parolees, right? They be sending them back for stuff like this. This ain't really serious like that, right? I cannot answer that because I don't know. I don't know what you've been up to. I don't know what you've been doing. I don't know whether they like you. All right, man. Yeah, we go. Yeah. Sir, do you understand that? Yes, sir. Now, if you want me to, I don't really want to, but if you want me to adjourn it out so you can talk to your parole officer, I'll do that so that you can be absolutely sure what you're doing.
Want to talk to your agent?
I'm gonna go ahead. It's cool. You're gonna go ahead with that? I'm just leaving guys' hands. Okay, so.
Sure.
It all is anyway. All right. So you understand that by entry of your plea, that those two things could happen.
Yes, sir.
And understanding that, do you still wish to enter the plea of no contest?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any manner?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 25-15008. Any objection to the court having reviewed that report?
No, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, and you commit misconduct as defined by the Michigan court rules, any sentence evaluation or agreement, the court would no longer be bound by, and you could not withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
It's all on the record, Judge.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
You have, Judge.
Court will accept the defendant's plea of guilty or of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be. Is this the only thing holding him right now?
I mean, he has a parole hold as a result of this, but just this case, Judge.
Don't I got something sooner, don't I? I have an October day.
We'd appreciate it.
Hello? I have an October date.
You have October 22nd.
Thank you. Yeah. Sentencing will be October 22nd, 2025 at noon.
Thanks. Thank you very much, Judge.
You're
Thanks,
welcome.
sir.
Bond will continue. Thank you. Oh, they're waiting.
Yeah.
This is a span.
No, it's not. So I have, yeah.
Okay. Is he out? Okay, so you can go ahead and, yeah. Court does call the case of the people of the state of Michigan versus Darnell Taylor.
Good morning, Honorary Tam House System Prosecutor Trudenbaum.
Assistant Public Defender Ben Dunaway on behalf of Mr. Taylor, who's joining me at the podium now.
Your name, sir?
Darnell Taylor.
All right.
Your Honor, this is the day and time scheduled for a preliminary examination. People are unable to proceed on count 1, the aggravated stalking. Your Honor, we would motion for remand on count 2, telecommunications services, malicious use for a domestic relationship, as well as an added count 3, stalking misdemeanor, and for 1 year, up to 5 years of probation and $1,000 fine.
Do I have a new complaint?
No, Your Honor, I'll get it to the court.
Okay. All right.
Your Honor, if the court was inclined to grant the people's request for remand, could we address bond?
Count 1 is dismissed. I will remand it to, I'll continue as not guilty plea as to count 2. As to count 3, do you waive any further reading, the presentation and reading of the complaint in that matter?
So waived, Your Honor. Thank you.
All right. And how does your client plead to that added count 3?
We will stand mute.
And then having waived for reading, standing mute as to count 3, which is stalking. All right. Court will enter a not guilty plea. Pretrial in this matter will be set in the 15th District Court on
October 29th at 10:30 a.m.
October 29, 2025, 10:30.
Yes.
10:30 before Judge Perry. As
Your Honor,
bond.
We'd ask for PR bond, Your Honor. The complaining witness on this particular case has, I believe, failed to appear at court at least 4 times in 2025. So the idea that, they're going to be able to proceed at any point, and this is on other cases, not just on this one, but.
Okay.
Right.
Okay. Go ahead.
Well, the idea that they're going to be able to proceed on the remand, I think, is fictional. She never comes to court. So it's being remanded for the only purpose of keeping him in jail. He's being held on something else, but we think we're going to resolve that before the 29th. So I think the remand serves no other purpose than to incarcerate my client.
What's he being held on?
He has a domestic violence case with the same complaining witness. The facts in this case have resulted in a motion for bond revocation that's up tomorrow with Judge Conlon. Now, we're going to be dealing with these issues and dealing with that case, but on this particular case.
Go ahead.
Well, I view them as separate. I know the court may not, but we're going to be dealing with the Judge Conlon Circuit Court case. On this particular case, the complaining witness has failed to show up at now 4 preliminary exams by my count in 2025. Okay, and one of them was found over on 27C, but she's literally never testified under oath. There's no injuries on that case either. So we're in a situation where the complaining witness is saying Mr. Taylor's doing some bad things, no question, but she never says that under oath, and he's spending a bunch of time in jail. So we'd ask the court to let him out, let him deal with his cases. I think a no contact order would be sufficient to keep him physically separated.
When is he up on the other case? I guess I'm trying to figure this out because you're saying I'm looking at them together, but they are related to each other in a sense. Go ahead.
Up tomorrow and. And if I may respond.
Yes.
Your Honor, this is a very long history and one of those classic patterns of course of control. The victim not being present today falls right into that. I mean, for this case, he was sending her messages telling her that he was going to cut off his tether and come kill her, messaging her on Facebook, using different numbers. Again, I'll kill you and him, threatening 2 people, not just her. She's continuously being threatened. And as these things continue, and this basis for the violation, it's completely understandable for anyone who's aware of domestic violence dynamics that she's not present here today. And while we cannot proceed today with the felony count, if it comes down to it, we would motion to proceed under 768-27. And if that's what we need to do, then we'll go ahead and do it. I don't believe that that's what Mr. Bender wants us to do, but if that's what needs to happen today, so be it. I guess that's my position. Our concerns about the victim's safety have not lessened. If anything, her not being here today just adds to that concern. So if we need to use the tools that the law allows us to use to protect her, we certainly can. I'll need some moments to prepare for that, but I have no problem doing so.
I think the court already dismissed the felony charge, so I don't believe they would be able to proceed on anything. Your Honor, we'd rather have the remand than them proceed on 27C if that's the question. My position would be that it's already been dismissed though. So I think the court can, make the ruling.
Okay. He had another case that the victim didn't appear, but was able to proceed to the point where it was bound over, correct?
Yes, and I held that exam, Your Honor.
There's been additional.
There's additional information for might want to be over.
Tana, always, yes, come on. I knew it.
Prosecutor moves to dismiss in the interest of justice. McNally Pros, case dismissed. Release defendant, and you're all set. Okay, thank you. Thanks. Good luck. William Frank Weisenstein, 25W723254.
And Leah Beltram, I think to my mistake, approaching, sir, come to the podium and state your name.
Jury trials.
You know it. Yeah, I'm not dismissing my.
Your name?
William Weisenstein.
So we need a jury trial date.
Yeah, Judge Burke, set it for November 21st.
I thought you just said you weren't available. Oh, he wasn't. Yeah, that's good. Jury trial, November 21. I'm good that day, right, Heather?
I believe so. Let me just double check, Judge.
And then jury instructions, you guys are gonna put them all together, so I just have to read them, right?
Yeah, Judge.
Jury
Judge,
instructions do, I'm sorry,
You do have a general civil jury trial that day.
what's that on?
It looks like active life and
We're gonna say-
Allstate insurance.
We're gonna make this due November 7th. Is that good, or you guys need more time? You want the 14th? I'll give you the 14th as long as I don't have to bug you to get the jury instructions.
The jury instruction 5 to 7.
Perfect. Jury instructions due November 7th, jury trial November 21. No reason to set it for a final pretrial, right?
Witness list, exhibit list.
You guys, that's up to you, whatever you want us. You want to submit those on the same date?
That's fine.
Yeah, submit those on the same date and we'll see you guys here. Anything else, Ms. Belcher? Have a good day. Sir, any questions?
No.
All right, thanks a lot, Ms. Ellery. Nothing else, right? Okay, thank you. Thank you. All right. How are you? Good?
Here you have a 2 o'clock.
What's that?
I heard you have a 2 o'clock.
Oh, yeah. 2 o'clock.
Okay.
Good.
Yeah.
Not hard.
One second. Is it ready?
Well, you saying the whole time because.
Yeah.
But they weren't gonna be.
The one I'm supposed to be.
I think they'll be, what I'm used to see it.
Are you gonna go again? Yeah. Bye.
Take care.
Good.
All right,
Thank
is it, anybody have a case that's ready? Mr. Chunky, you have one that's ready? Okay,
And then Brownstown's trying to log in, they're having difficulties.
perfect. People against, Nicholas Philip Peak. This is file number 23T727397. And then I also have 23B144572.
Good morning, Your Honor. Mr. Secretary, you have my point. States might be about
Your name?
Nicholas Peak.
I can't believe. What did he do here? I mean, he just decided not to show up. Does he have, tell me he has the money to.
Well, he doesn't have the money, but I do have some favorable information, Judge. Last year, he was in treatment, Jefferson Rehab from March all the way to December. And then when he.
March of 24 to December of 24?
Correct, Your Honor. And furthermore, he was in treatment from February 1st to October 1st at Mission Bible Training Center. So he's been in treatment, so at least he's not been getting into trouble. He's accompanied by his mother today. He just got out and was looking for employment, but he wanted to come in. I advised him probably would have been a better idea to come here with money, but I think it's a good idea that he came in at all. He didn't have to get arrested.
Mr. Peak, what, you didn't write to us, when were you in 25? You got out in March?
February, March 24 to December 30.
I know that, but then in 25,
Yes, I've been in contact with Judge Oda.
listen to my question. When were you in treatment in 25?
February first to last week of this.
Oh, just last week? All right, I'll tell you what.
Yep.
Can you pay anything today?
I will be able to pay immediately. I'll go get it done.
I didn't place them on pro. Oh, yes, I did. Well, we're gonna have to do this. I can't just extend probation like the. We even let you zoom and you still didn't even zoom.
No. Justice said that.
I'm talking about March of 25 when you were supposed to be and. Said right on the notice. Counsel, I'm gonna need to take a plea or what have you on this case. He's on probation.
Yeah, it's to a violation and we clearly he's failed to appear, so we're not gonna ask a hearing testimony.
All right, if you plead guilty here, sir, your probation could be revoked. You could be incarcerated since you absconded for a period of 65 more days. Do you understand that? You're entitled to a hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes, sir.
If you're going to plead guilty to failure to pay your fines and costs as ordered, you understand the possible consequences.
Yes, sir.
To that charge, failure to pay your fines and costs of 810 as ordered. How do you plead?
Guilty.
You fail to pay your fines and costs as ordered?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
Does he still owe 810?
Yes, Judge.
So I'll accept that plea. Let's see. He's only got until March to pay everything.
Judge, he seemed pretty convincing when he came in. He's gonna be getting a job. He's accompanied by his mother, Dave. Appears he's got strong family support system, and hopefully this treatment has put him in the right path.
Probation, sir, is there anything you'd like to say?
No.
Probation is, well, there is no probation, right? I didn't know. Yes, I did. I did order probation. I'm sorry. Probation is extended. Until March 5 of 26.
As a payment plan, Judge, he indicates he can make a minimum payment of $100 per month, but he's gonna try to exceed that. I guess that begins potentially.
I mean, I can't, he's not gonna have it done if I only order 100 a month.
Your Honor, yeah, whatever it is that we to
I pay 150 per month, and I'm gonna start this beginning November the 7th. Now, but all money due, I won't charge you probation fees, but all money due by February the 25th of 26. Okay?
Yes, sir.
Mr. Peak, you're gonna get your life in order, or are you gonna? And on the other case, I see he's requesting time to pay. I always love that. Time to pay. How much does he owe on that one, Heather? Can you tell me? In front of Judge Hessen, 23B 144572.
He has a balance of 340.
You can't do this. I'm just gonna give you a due date for this, and it's gonna be December 29th of 25. So you're gonna have to incorporate that in your other payments, okay?
Yes, sir.
We'll give you a printout down the hall. If you need more time, come talk to me. Ignore me again and then come in. You're going to jail. You understand that?
Yes, sir.
Good luck. Alyssa Young. Alyssa Leanne Young. 25B 718619. Is she yours?
Yes, Judge, that's a Brownstown case. I believe that she's on Zoom. I was Detective Tula said that she's in. She's coming in now.
All right. So I got Alyssa Young, Lexi Don, that's on Brownstone stock. All right. Good morning. Your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
And where is the defendant?
I have them both sitting here with me. I have Miss Dawn and
Let's
I
bring
have Miss Young.
Ms. Young in there, please.
All right, Miss Young.
Your name, ma'am?
Alyssa Young.
All right, state your name again, counsel.
Good morning, Your Honor. Mr. Shep, preparing to have my client, Simon Simpson, being here via Zoom, as the arraignment wait for reading my client's baby.
All right, so she's got here. It looks like 3 counts of OWI occupant less than 16, which is a 1 year. Does she have any prior alcohol related convictions? Can anybody tell me?
No, Your Honor.
Can you tell me what the breathalyzer or blood result was?
Yes, Your Honor. The intoxilizer results were a 141 and a 138. And at the time, she had her children, 3 children in the car, that one that was born on June 19th of 2019, one that was born on October 29th of 2021, and the third one that was born on February 13th of 2023.
Where do you live now, ma'am?
Inkster,
What is your address?
26716 Ross.
ROSS?
Yes, sir.
What's the zip code in Inkster?
48141.
Who do you live there with?
Myself and my 3 children.
Do you work?
I do. That's where I was coming from.
Where?
I work at Burger King on Michigan Ave. About 5 minutes from my house.
What are you asking for there? Anything, detective?
Your Honor, we would just ask for an order that she not be able to purchase, consume, or possess alcohol. We'd also ask that she have a sober link tether, given the severity of the offenses and the 3 children in the car. Otherwise, we would leave it within the discretion of the court.
Any argument, counsel?
Your Honor, she's gainfully employed, obviously in the circumstance, she probably, she doesn't want to be able to employment. I'd ask the ratio for a personal body searing lack.
You got warrants out for your arrest. If I set a bond that you can't make, who's going to take care of your children, ma'am?
I don't know, because I'm their primary caregiver and my daughter's disabled from her neck down, but I would have to make calls, and
Who's with the children now?
I believe their father.
Got to get
Or
your
my
life in
sister.
order. You got to get your life in order. Give her an AA sheet. Ma'am, I'm going to give you a $2,500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with prosecution witnesses except through your lawyer. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to attend AA twice a week. Every time you go, and you do have to go in person, you have to have the form signed. Every time you come to court, you have to bring the form with you. Do you understand that?
Yes, sir.
All
May I
right.
ask, is it 10%?
No, I'm just going to give you a personal bond. You don't have to post any
Okay.
money.
Okay, thank you.
This is your lucky day, but you got to show up in court. Do not make this worse than it is. Do we understand
I got
one
you.
another?
Thank you,
You
Your
have-
Honor.
You have to have that form signed, okay, every time you go. The A
Yes,
to
sir.
AA, and you have to go in person. October 28th at 8:30 will be your court date.
Yes, sir. Thank you.
Any questions?
In 2018 out of Harris County. Then you just move around the state and just assault people. Then you've got another in 2020, a family assault conviction out of Fort Bend County. Oh, here's one. We've got another family assault conviction. These are all felonies out of Harris County, Texas. Now you want to come into Jefferson County and make a mess, mister?
No.
Are these women that you're assaulting?
It's a woman.
Is it?
It's a woman.
Is it?
Yes.
Okay, Mr. Man. What are we gonna do?
Just,
To the person who assaults females regularly?
Just with this being his announcement, I'm sorry, initial appearance, I was gonna put it on the announcement.
He's a habitual felon, right?
Right, and I also.
It's looking at a minimum of 25 up to life imprisonment, right?
Right.
That's minimum. Okay.
I don't want to put.
I think a jury wants to hear this in our county. This isn't where he's going to end up to assault. For his long history of assaults, we're not going to end up here. You're going to go to trial. We're gonna let a jury here in Jefferson County decide your fate
Yes, sir.
because they really don't find this sort of behavior amusing here. And you've moved around the state. How many different counties have you been convicted in for felonies? 1, 2, 3, 4, now 5. You sure there's nothing wrong with you mentally?
Not that I know of, sir.
Not that you know of? You don't know the difference between right and wrong?
Yes.
Do you know the difference between assaulting people, that's a crime and that harms others?
Yes.
You've been convicted several times of this, so it's not like it's their problem. It seems to be yours.
Yes, sir.
Well, we're gonna stop the problem in this court.
Yes, I understand.
All right. What do you want to do next? Was this an initial thing?
Yes, sir. I was gonna put it to the announcement, but I think what you're saying is you want to put it on the trial docket, right?
Yeah. Yeah.
It's gonna put it on the trial. Absolutely.
And here's another situation. Who is this? I'm not going to name the person that you assaulted because I don't want to, I'm sure they've been embarrassed enough by you.
So,
You're going to interrupt me too?
also, I apologize.
You get to speak. You have a fair opportunity to speak, but I sense your personality is dominance over others. That you're going to keep interrupting me
Sorry.
and proving it.
Yes.
You finished? Now can I speak?
Yes.
Mr. Rude Guy? All right. All right. What was the relationship of this person to you?
That's the mother of the children.
The mother of your children?
Yes. She does have a lot of mental issues.
What did you just say?
She does have a lot of mental issues. She actually.
She's not the one convicted here 5 times.
Yeah.
You're blamed.
I'm not.
That's the jury's going to love that when you get to speak. Yeah. I don't mean to be facetious, but this is extraordinary. Generally, people don't show up with a rich criminal history. You know, you were a habitual felon 2 convictions ago. You had reached habitual felony status. You were looking at 25 to life before the last 2 convictions, which are the same type of offenses that you're here for today. Well, do you have any contact with this person other than when you assault them?
I haven't recently. No, sir.
I want to know when you do. The next time you do, your bond will be revoked.
Yeah.
You have no contact with this person. If I find out,
I'm sorry about that.
when you're through talking again,
No,
Mr. Interrupter,
I'm sorry.
what a bully. What a bully. I can see how you would bully women. Yeah, and have a rich history of it. Convictions of assaulting women. Well, it's going to stop. I find out you have any contact with this person, your bond will be revoked and you can sit it out in jail until we get around to trying this. Plus, you're going to have a GPS device. You have one now?
Yes, sir.
So that if you have any contact, we'll be able to find out where you were at any given time. You understand?
Yes, sir.
All right. Okay, put on the trial docket. Thank you. That's all.
Yes, sir.
Lairborn Livings, Langston.
Please, come on up. Piece of that. Piece of.
I'll let you next.
What are you going to do with Mr. Living?
Just put him on an announcement, Judge. That's all I want today, from initial to announcement.
Yeah.
Thank you.
The victim in this case, Mr. Livings, do you know the burglary victim here?
It was my sister's friend's mom's boyfriend.
Okay, you can't have any contact with these people. You heard what we talked, and that's a condition of bond anyway. I just warn people because they go, oh, I didn't know that, but you got a lot of bond conditions. And if you have make contact with the victim without the proper authority, then you lose your bond and then you sit it out in jail until the trial. So get a resetting for announcement. Chastity Rashman. That's Kyle Gasper is the attorney.
Yes. Just over here. Chess. She's kind of. That's not mine. That's I don't think she has a lawyer.
You don't have a lawyer, do you, man?
Yes.
Come on up. 25 CR 1041. You're charged with assault on a peace officer, which carries with it up to 20 years in prison. It's very serious. Langston, this is you.
I don't believe she has an attorney yet, Your Honor.
If you, I can.
You're Chastity Rashman?
Not from here.
Are you Chastity Rashman? Look at it.
If you tell me, well, I can do
Well, I
that.
didn't even know what courtroom I was in today. So,
I don't mind. I mean, I'll be happy.
Well,
I didn't get anything.
You didn't get-
Look at the
I'm not
docket.
seeing it on Odyssey either.
Look on the docket.
I'm looking at it.
It don't
but-
have me at all.
I know, but what was that thing I just gave you? That you just took?
And was it now? I don't mind. I help him.
Well, I mean, how does this get?
I have no clue.
That's so weird.
But that's not no problem. I can get with her, and if you just put me on an announcement, I can meet with her outside today, and then we can put together a plan, and I can get with Mrs.
Do you have your own lawyer?
no, I don't have a lawyer.
Are you able to hire one?
Not at the moment because I lost my job.
Okay, well, Mr. Adams somehow got placed on as,
It was back when she was arrested in the jail.
Because they took me twice and I didn't understand it either.
yeah, okay. Well, we're gonna put you on the list for her, okay? It's, talk to her, and this was an initial appearance, so we'll put it on in an announcement, but get with her, okay, while you were here in Austin and she's here, so you'll talk about it. Okay. Did a resetting, man. Thank you.
Wait till you talk to me.
Yeah, from her, and then you can talk to him. Caitlin Rodriguez. Caitlin Rodriguez, please.
Ma'am, you need to kind of read that in.
Yeah, yeah, you don't get out here without putting your autograph on something.
No.
No, just stay.
Just not right there.
Caitlin Rodriguez, 25 CR 787. No answer in the courtroom. I am asking the bailiff, please call into the hall for Caitlin Danielle Rodriguez. And this is cause number 25, CR 787. Hey, Langston, bad news. This is one of yours too.
Not again.
Yeah, there it is. Look.
They didn't have me on the docket.
Oh, my God.
Hey. Look.
You're in a slump right here, right now. A couple of bad innings. All right, there is no answer in the courtroom for Caitlin Rodriguez, no answer in the hallway called by the bailiff. Defendant has failed to appear. A warrant shall be issued for her arrest. Her bond was in the amount of.
Section currently has a pending warrant for her arrest in this case.
When was that issue? This resetting was issued in August.
I'll make it work.
Bonded out in another city or another county. How can that happen?
So it looks like Judge Lee issued this warrant back in August 22nd. We issued the warrant back at August 22nd. The bondsman wanted to get off the bond, and we set her bond at $20,000 plus GTS plus home confinement.
Okay. But she's failed to appear today, right?
Right.
There's no answer. So a warrant is issued for her arrest, no bond at this time. Mr. Green,
Judge, she's advised that she's hired Tom Burbank. He's supposed to meet her here today.
where is Miss Green? Come forward. Come forward.
I received the email notification he's hired, Judge.
Strangely enough, he's not here.
He hasn't made it. She told me.
Come on up. So, you have indeed hired Mr. Burbank. Okay, well, he's late for work. You've already paid him? Yes. Okay, just have a seat then. We'll wait for him. And Tiffany Butler was reset.
That's correct. She hired an attorney.
I'm sorry?
She hired an attorney.
That's great. That's a great thing. And that's important. Independence is good. Who was it? Do you know who's been hired?
I was just notified that she had hired someone.
Hey, Langston,
Yes, sir.
Yamuel Burgos. We're on the 9:30 docket. I'm gonna need the 9:30 finals.
Wow. What?
You want half, all of it.
Half's good.
Hey, Judge.
25 CR 713 Yamuel Burgos. That's you? What is that name derivation? Is it Burgos? I'm not familiar. I've never known anybody Burgos. What is it? European name or something? What do you don't know? The family name is Burgos. But Yamuel, that's interesting. Where'd that come from? That's Bible? Is that a Bible name? No? Okay. Samuel is. I thought Yamuel would be close. Right. Okay, so
Judge, I just want to.
Langston Adams is your attorney?
Right. Judge, I just want to put for the record, I have met with him on this case, gave him discovery, gave him police reports. The offer is deferred adjudication. I let him know that it would be a deferred $500 fine, which doesn't be on your record. He's adamant of saying that he has nothing to do with this. They got the wrong guy. He is, what you tell me? You say you didn't have nothing to do with this? So that's what he told me.
Okay. The victim in this case, do you know this person? The victim in this indictment? He went over the indictment with you, right?
I gave him. He got that.
The name is in there. I'm not going to say the name because I don't like victims' names being called out. But this states you discharged a firearm at a person and property. It looks like it's somebody's home on Maddox Street. You don't know anything about this? You don't know this person who lives there? Okay.
He's saying, he told me that they got the wrong guy. He has nothing to do with the case. And that's the name Judge is referring to. We don't have to say it, but that's the name in the indictment. Do you see that name? Yes, sir. He's saying that he has nothing to do with it. Not just keep that with you because he actually came. That they got the wrong guy. So, but like I said, I did let him know about Mr. Laird's offer of the deferred adjudication. $500 fine was the offer. But again, he's telling me that they got the wrong guy. He has nothing to do with this, right? So I just want to make sure I voted you correctly.
I'm looking at the probable cause affidavit, which states that surveillance video confirms you arrived at the scene of a shooting in the vehicle. You exited the vehicle, walked toward the area where the shooting occurred. Immediately after, you returned to the vehicle with your injured brother. the female and two other individuals, all armed with rifles. Then you drive the vehicle away with the others as BPD, the Beaumont Police Patrol units arrive. And all of this is clearly shown on video. That's what this says. Okay, we'll set it for trial.
Yes, sir.
It's a third-degree felony, which carries with it up to 10 years in prison,
Yeah, you
just for your information.
Here, sir.
Jawan Kolar was reset. I've got Jasmine Dudley next.
Come on up, Ms. Dudley. Judge, when we were into the last on Mrs. Dudley.
Jasmine Dudley, is that you?
Yes.
The pawn had evaluated, well, was supposed to evaluate her, and he came out with his report, I think early September, I could be wrong. I got a copy of it. This is it right here.
Judge.
Uh-oh.
You got a warrant for your arrest. You're not going anywhere. And we've got to process that first before
So
we get to this.
He just can't, well, not just, he found her competent, so in light of her new case and then what you're looking at right there. Let me see what I can do to try to work that one out.
Mm-hmm.
But when we here last week, looking on that.
Okay.
So I guess in light of this new case, I'm resetting, I can get, Judge, you gonna point me?
We've got let me make sure I've got a copy of this in the phone. I do.
We will. Hey, Jim.
Mm-hmm.
Hey, you gonna point me on this new case you just got picked up?
On Jasmine?
Yeah, the one she just got the mark for. If you can put me on that one, then I'll try to take care of them.
Yeah, we're gonna assign Mr. Adams to handle that new case on that warrant, as well as 25 CR 364 reset a week. Okay. All right. Cedric Marsh.
He told me Ryan Kimbler hired him.
And Mr. Kimbler did.
Wait, Ryan Kimbler hired him?
Oh, I'm sorry.
That's been long overdue. I was wondering who Rife was gonna hire to represent him in all these matters that have been piling up for years.
I'm just slow. That's you got. I'm sorry up there. Yeah.
Ready to go, Judge.
So,
just March.
Yeah, I did a notice, he filed a notice on it.
Okay.
Tonight, we just March.
Yeah.
Here's Dudley's too. When did you send that in to us? Because when? Oh, it's still on horseback somewhere. All right, in Cedric Marsh's case, you were charged with this third-degree felony and cause number 25 CR 582. And Rife Kimbler, that's who you decided to choose for your attorney, right?
Yes, sir.
Okay, we're going to put this on an announcement. Okay. Is that okay with you?
That's right.
Yeah.
You're stuck over there.
Desmond Papillon?
I sent that to you, Judge. You got this. Paperwork all.
Have swear in front of me, take the front.
Mr. Passion. Yeah, I sent it to you.
Sir, you need to come swear in, finger in front of me. Yep. Please raise your right hand, you swear or affirm to tell the truth and truth and nothing but yourself you got. You give your right thumbprint. Okay, place it flat right here on this box. You can have one more time. Place it flat right here. Okay, I'm seeing in front of judge.
25 CR 780 is called. You are Desmond Jerome Papillon Jr. Correct. And you were here with Mr. Adams, your attorney and the state's attorney. I need a pen. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 17th, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you were charged with? If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand? Okay, an agreement's been reached in your case. What will it be? I'm waiting on the pads.
Yes, 5 years deferred, $500 fine. 5 years deferred for $500 fine.
Apparently, there's an agreement that's been reached where you're going to be pleading guilty here and placed on deferred or unadjudicated probation for 5 years. Is there any restitution?
No, Your Honor, the vehicle.
Fined $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan? Yes. You have to speak up so she can hear. She has to put everything down.
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this? Guilty or not guilty?
Guilty.
I can't hear you and I'm right here.
Yes.
Okay. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Oh, you already signed it. He's asking me if this is your signature. Oh, yes.
Okay. State's Exhibit 1 is tendered into evidence.
Yes.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. And you were doing this freely and voluntarily. Are y'all gonna be working on something? Let me know so I can get you in and out. Okay, yes, sir. You were mentally competent to enter your guilty plea. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. Made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement and I'm going to find you are indeed deemed mentally competent. You understand and appreciate the consequences of pleading guilty. Your guilty plea is freely and voluntarily made. You were giving up your rights to a jury trial. And you were entering your guilty plea voluntarily, knowingly, intelligently, and based upon discussions with your counsel. I find that there is enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am not going to find you guilty so long as you follow these terms and conditions of probation. You will be placed on what we call deferred, postponed, or unadjudicated probation. These are normal and customary terms. Most of these terms of probation I have to follow every day, and all of us have to follow. This will be for 5 years. You'll be fined $500.
Wait, hold on. Where do you want us out?
Here we go. Please see the probation officer and you'll begin probation. Do well, okay? Yes, sir.
It's that one over there.
On Logan Birdsong.
Birdsong. Yeah. Oh, okay. You got, you got.
I'm gonna let you rest, Langston. You look tired.
No problem. Well, your feet are a bit tired. I know.
Langston Birdsong and also Juan. Those, the one for the ones that Mr. Walker's handling.
This one's here. Walker's fire.
Busy with these. Logan Birdsong. That's you, sir? All right, what are we going to do today? Here's an announcement.
I'm still doing an expert report out of Houston. And it's later than this. You know, Paul, you try to do something.
Yes, sir. But how much time you need here for this next event?
I'll have an expert report 3. But he's out for Houston in the KB area.
Okay.
Been impressive.
Can we review it in 3 weeks? See where we are on it? Okay.
Yes.
We said 3 weeks on that one. Juan Figueroa.
You can stay.
Just get a reset. Juan Figueroa. It looks like I have 2 cases on Juan. That's you, Mr. Figueroa? 25 CR 730 assault on a peace officer. And
I don't know how I did it.
25 CR 731. Looks like this must have been out of the same event. 2 officers are deemed to have been injured, it looks like, or assaulted. Because it's April 29th, 2025.
Yes, sir.
And I need to see 2 different names of people. Who have been apparently threatened with assault. Who
Yes,
were
sir.
public servants. Okay. Which, by the way, carry with it, these are 2nd-degree felonies, sir. So you're looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 for each case. You understand? Okay, serious. Today.
We're going through discovery. Judge, and we'll get.
How much time? 3 weeks, you think is enough, or 4?
4 would be.
4's good. Okay, you got it. Yes, sir. Gerardo Galvan.
Yes, sir. Who's here?
Mr. Galvin? Galvin?
I don't know how I did it for me.
You go to the restroom or something?
I think he's in Paul's office.
He's doing filing at the clerk's office?
I think he's at the passport office.
Oh, the passport.
Where's he going?
Here in this building?
Yeah, I was gonna say, depends on.
Where's he? Well, I'll probably whether he's staying or not. Good luck with the passport. That's not him, is it? Right there in the doorway.
Yes, sir. Here's.
Come forward, sir. Mr. Galvin. 23 CR 1089 is called. You are here with Mr. Walker, your attorney and the state's attorney. You're charged with a 2nd-degree felony of sexual assault, carrying with it up to 20 years in prison. Very serious. Today it is an
announcement. Just
announcement. How much time?
I need a little time to contact the victim. This was Ms. Staub's case. It looks like
4
they
weeks
tried to
good?
contact the victim, but weren't able to get a hold of her.
4 weeks good, everybody?
Yes, sir.
What do you think?
By then we should be
Mr.
resolved by
Walker,
then.
good for you? Okay, reset 4 weeks and one more. Gerardo Galvin.
No, we got that. It should be in the one cup, and that's gonna be a plea for schools and judges. The one cup.
Oh, I got one. I'm sorry.
Yes, sir.
Yeah, Mr. Galvin was this one. Lawan Kirk.
Yes, sir.
I don't know how I did it.
There is how working. Okay, let me know when y'all are done.
It's outside sign of the room.
Great.
Thank you, sir.
All right, what are we doing with Kurt?
Reset 4.
It's gonna be a plea.
Oh, Kirk is.
Yes, sir.
I'm sorry. Galvin is reset 4.
Right, I think that's
Kirk is plea today.
It's volume over there.
John, Matthew Graham.
No.
John West.
Yes, sir.
And Matthew Graham. And it's our announcement.
It's an estimate. We can get about 4 more weeks so we can go over the discovery and we'll see if we can resolve.
You don't have that.
No,
No, I didn't give you the rest. I only gave you Walkers.
I'm running fast today.
Just for the record, Your Honor, my client no longer lives in Beaumont. He has moved away. So I know there's probably issues with it. I know you're about to say no contact with the victim. About last time, when he was like, it's initial, he no longer lives in Beaumont.
Where?
He lives in Navasota now.
Is that right?
Yes, Your Honor.
Okay, I need a. And go ahead.
If we just need about 4 weeks, Your Honor, to go over discovery and
Reset, get a reset.
reset.
Thank you. Damian Walls.
Which Walls?
Says plea hearing.
Yes. Can we hold on?
Working on
He wasn't
that?
here earlier. Yeah, let me take care of that.
Oh,
It's finally highlighted that one.
hey, Don, on Misty Green,
Not right. I just highlighted that one.
okay.
Yeah. All right. There you go.
Shelby Smith,
Shelby Smith, I don't believe that, when I call her name, I don't believe she's here to, oh boy. I don't.
25 CR 706 is called. The state of Texas versus Shelby Brooks Smith. There is no answer in the courtroom. I asked the bailiff to call into the hall, please, but Shelby Smith. What is her bond?
He had an active warrant for her arrest. The bondsman wanted off the line, so he set the bond at $10,000.
Who did? Okay.
I believe she was on probation out of Orange County when this offense occurred too, so she may be in custody there.
Well, she's got her problem with the bondsman if she's not paying the bondsman, but
Yes, sir.
her problem with me pointedly here will be failure to appear. And her bond was how much?
He set it at 10,000. The bondsman asked to get off the bond.
All right. Failure to appear. So now the defendant's bond is $25,000. And she must have a GPS device. So we know where she is when she's not in court when she's supposed to be. And a warrant shall be issued for her arrest. Yeah. What else do you have?
I think that's all I got for you today. I think that is.
I have Jadarius Hamilton is reset. Correct, everybody?
Right.
That's what I'm looking at. Don Junkanita Brown, June Kanita. I know.
She's working on paying restitution. The case is going to eventually be
Where is
dismissed.
that you, man?
The case can eventually be dismissed by the state since she completes restitution.
How much are we talking about?
She's got about 5,000 left, out of a total of 10,000. So a couple of months, I think we'd be well underway.
So you're getting it paid back.
Yes, sir.
About how much time do you think you're gonna need to get it taken care of?
Then to go through the settlement, and the settlement is $4, so I would already practically be done. I just need to reach out to them to make sure that they want to abide by it.
I'll say 6 weeks, maybe 6 to 8 weeks.
And the court ordered it and she has been paying to our office. I know she's made a payment of 500, 200 and several, I think totaling around $1,300.
But she's also paid some directly to U-Haul and they're negotiating whether to get it.
Who used, sir?
Here's Hamilton.
Okay.
Your case was reset. Your case was reset.
To win. Who's his lawyer? Okay, so when will it be paid?
I just need to talk to them and make sure that they're okay with the settlement that they offered me.
You-
If they're okay with it, I've already.
You got it ready to go? Okay. All right, why don't we review it in 3 weeks? 3 weeks? It might be
I think it
done.
may be a little, maybe 5. That's
It's
okay.
3 weeks, almost.
Okay.
Do you think 3 weeks is a good chance that if they agree, then you got it, right?
Please, so.
Well, and if you need some more time, no problem. But let's just look at it in 3 weeks, okay? Ms. Brown, get a reset. Thank you.
Okay.
That's not what happens.
Reagan, on Renuka holiday, what are we gonna do on Renuka?
Forms to get from the office to watch them, get this meeting, but I need to review that and to discuss. Should be all.
Where is she?
She's in the back.
Renuka holiday, I need some more files. Reagan.
The rest?
Oh.
Okay.
Go ahead. There we go. Renuka?
Yeah.
Holiday? Okay, so, you were here with Ms. McNally, your attorney. And how much time again?
4 weeks, please, Judge.
Okay.
We have an offer, but I need to run through the discovery with her so that we can make a decision moving forward on what way to go. And I just haven't had time to do that with her.
Okay, 4 weeks, get a resetting, please. Thank you. Julio Ramirez,
He's a sentencing judge.
the third. Mr. Ramirez, come forward.
How many that's for?
And we call 24 CR 1277, State of Texas versus Julio Rolando Ramirez the third. That's you.
Yes.
With Ms. Manali, your attorney and the state's attorney. Earlier, the defendant believed has entered a plea of guilty in this cause number 24 CR 1277, charging the defendant with this indictment of a third-degree felony of failing to comply with sex offender registration. Pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any corrections or changes to it? State.
I'm reviewing it now, Judge. I have no objections.
Defense.
We don't have any objections, Judge. We just have a clarification on page 3 to do with the criminal history. It says no of Crossify. I don't think I'm saying that correctly, but I didn't have a chance to clarify for my client that basically means that the charges were dismissed or were not proceeded on by that other entity. But that's the only thing that I have.
Okay.
Outside of that, we have no.
Then the pre-sentence report is made a part of the record for all purposes. And the agreement in this case is a cap of 5 years imprisonment. So this is third-degree felony, so we're looking at no less than 2, no more than 5 years confinement in prison. And I guess deferred
Or straight.
or straight probation are also options. Couple of things that jumped out of the court as I was highlighting here. Sentenced to 3 years imprisonment for failing to comply with sex offender registration requirements out of Madison County, Texas. And it looks like that, strangely enough, allegedly occurred in 2016, and he was sentenced in 2024, 8 years later, which is mystical. That's an odd situation. I don't know what the deal is on that, but nonetheless, the defendant has a previous conviction for a similar offense, failing to comply. So it's not like you don't know that it has consequences if you fail to honor the conditions of law.
If I may, I previously, up until just the past couple of years, I've been pretty much homeless, going from place to place, sleeping on couches and whatnot. And I've recently been married and have now basically started to stabilize my life. And I'm wanting to get on the right track and put all this behind me. And I'm just hoping that I could throw myself at the mercy of the court.
Okay. Okay. Put this in context, and I'll start off with, it's never too late to do the right thing.
Yes.
And to make the right choices. But according to this pre-sentence report, you've been committing crimes for 30 years. But I'm just talking 30 years. I mean, that's what it says. 1995, you with the DWI, then DWI second, you've had probations revoked, drug possessions, probation, drug possession, paraphernalia probation, possession of marijuana, DUI in 07. And then we then kind of jumped over to the more serious crimes of several cases in 07 where you were put on probation, and then that was revoked. And then you were, so you got, I'm looking at 1, 2, 3, 6 convictions from that cluster of cases that you were placed on probation that you later, it looks like it was probation in 2007 out of Collier County, Florida. And then those were revoked in 2011. And you were sentenced to prison. Then after that, you have that failure to comply with sex offender registration and pick up 3 years out of Madison County. And then here we are. I think that's so never too late to do the right thing.
Yes.
But I wish you had done it before you picked up this last case. Okay. You see the recommendations from the probation office. And they do always a great job and they're forthright and they hate to see failures because of our track record that we're very proud of and success on probation. But based on discovered findings, it seems neither jail nor probation has been a deterrent for the defendant's conduct. Therefore, prognosis for completing any probation successfully is poor. Well, you can see what they're telling me. Y'all got an uphill battle here to convince me to place him on probation. In light of his rich criminal history here. But see what happens. Go ahead.
Judge, before I begin, I have two defendants exhibits that are letters from his wife and from his cousin that I would like to offer to you and into.
You're gonna call those like defendants exhibits 1 and 2?
Yes, sir. They've been marked. But they represent the current support system that Mr. Ramirez has from his wife and from his cousin. He has job opportunities that will come if he is placed on this probation. He has family members who are giving him a sense of stability that is clearly and has not been reflected over the last major parts of his life. I know that it was mentioned that jail nor probation is a deterrent for the defendant, but to me, that seems like even more of a reason to give him another chance, given this new sense of stability that he has with his family. He knows what he did was wrong. He is not inclined to make the same mistake again. I think given his new set of circumstances that he has currently that are positive in the sense of having that family support, having that spousal support, being able to make the difference and know the difference between right and wrong would weigh towards him being successful on probation at this point. Everybody deserves the chance to do that. I think that given the opportunity, he would show the support that he has changed, he has evolved. He is thankful for that new support system that he has. And this could be a really good chance for him to be successful on a form of probation. Do you have anything else you need to say?
Let me ask you, when did your life change, take this renaissance of change?
The last time I was, or basically the last couple of years that I spent in prison.
About when would you say this changed for making better choices?
Well, it said the last time I was arrested to serve my 3 years. The time that I spent in prison basically showed me that, yes, I can't be doing this anymore. I need to move on.
The Madison County situation?
Madison County conviction, yes, sir.
I think his wife provided a lot of support in that too. And it's notated that they got married around.
When were you sentenced there at that in Madison County? It doesn't make sense. This says this all occurred in 2016, and then I'm looking at it, what purports to be a conviction on April 15th of 2024, a year ago.
That's correct.
3 years. Is that right? So
8 years until it was resolved.
Why did it take that long? How could something like that languish for so long? Okay, I don't know. So when was when was the change in your life?
This last prison sentence that I served for Madison County. I saw that it was time to straighten my act up basically and do the right thing.
Okay. I'm looking at the probable cause affidavit here because something doesn't make any sense. It says on Saturday, March 9th of 2024 at approximately 12:47, I, Detective Boudreaux, and this is with the, he was Groves Police Department detective. And they do a great job. Arrived at this Lee Street address in Groves to locate a sex offender who has failed to register since 2014 for a decade. Was that right? Or is he falsifying an affidavit?
I wasn't here. I wasn't in Texas. I was in, between Texas and.
I'm gonna ask you one more time the question. This says you had failed to register since 2014 as a registered sex offender properly. Is that true or not?
Yes, sir. That's true.
Why do I have to pull that out of you? So it was a decade had gone by.
Yes.
But I mean, here you were living here, and I thought you had inferred that your life had changed for the better once you got married. But you're still a fugitive. How can you live like that? Any day somebody walks up to the front door and goes, "We got you." Finally. And you can't expect to be running for 10 years and not have the sky fall.
Yes, sir.
Okay. But like I said, we're going back 30 years. You've been in the system for 30 years. Are you saying finally now you got it?
Like I said, it's all started the last stint that I did in prison.
When did you do your last stint in prison?
I was just recently released.
When did you do your last stint in prison? When did you begin prison? Was it when the police in Groves got you?
No, that April 24th, or that April 15th of 2024 conviction from Madison County Judge.
When he resolved the charges from
Whether they come up to get him on March 9th and then they arrest you, right? The police arrest you on March 9th of last year from Groves. Is that right?
No.
Yes, that's the date. March 11th is the offense date, but
It says on Saturday, they arrived and locate who is a sex offender. Upon speaking with the resident, I learned he does still live at this residence, listed as absconder out of Madison County. I located him in November. I located Ramirez in November 2022, but he failed to register after being advised he was required to. He served time in Jefferson County Jail from August 23 until October 23. At this time, he still has not reported. So I guess they did not take you into custody that day. You must have gone into custody after that.
that's why I received theirs, because the offense date is not until March 11th, which is only 2 days later, but
He was indicted and charged in 22. That's what the officer is referring to about the November date, Judge.
but then
That case was dismissed because of the Madison County 3-year sentence.
He's living here. When is he taken into custody? I guess
I'm
that's
checking
curious. I don't see how contrived he is. He's aware. I mean, he's living here. You were living there when the police showed up, but you weren't actually there. But that's where you were residing. Otherwise, right? Okay, I want to know.
Yes, sir.
So you would know immediately if you weren't there. Somebody would have tipped you off. They just showed up looking for you. So, how much time after March 9th did you do the right thing? After 30 years of playing cat and mouse with the system here, I'm going to know how that happened. I mean, did you turn yourself in or did they finally catch it? It's just, it's an easy answer. You know this.
Yeah, yes. They did.
What?
What?
They caught you. Okay. All right. See, I don't, you gotta pull this out. So you really didn't, you knew about it, but why didn't you, when you heard that now you're caught in like a mouse in the trap, why did you continue to abscond? Bad choice?
Your Honor, the jail records reflects that he spent 10 days in jail on the failure to register as a sex offender back in August of 2022. He then spent another 60 days on that same charge after it was indicted in 23. That was the case that in your notes reflects was dismissed because of the Madison County charge. He was then arrested in March of 2024.
What date?
March 24th, 2024.
Okay.
And
Okay,
then-
so that would have been 15 days after they showed up.
So that
2 weeks later.
he served he was confined 9 days. Then he was rearrested on that charge on May 7th of 2025, posted bonds the next day. That's what our jail records reflect.
Okay. I think I understand. So what are we going to do here? State, what's your recommendations?
Judge, I didn't make this plea bargain agreement, but I made the agreement. It would not have been so generous. Looking at this case, the only thing that's appropriate is the 5 years. As the detective states, he needs jail time. As the probation officer suggests, and you've already quoted, his chances of handling probation is poor. The reality is he's kind of sidestepped issues all throughout. He's been given numerous opportunities, starting with the fact that what requires him to register. The judgment shows that he was charged with 69 counts of child pornography. Those were changed to 6 different charges where he was given probation that was revoked in 2011. In addition to it,
Is this the Florida?
That's the Florida offenses, Judge. He was given a chance to do probation then, and he was revoked because he was unsuccessfully terminated from the sex offender treatment program, which causes me a lot of concerns as far as that's concerned, as it's intended to try to prevent additional charges along those lines. So him being revoked for that reason is worthy of note. Then we get, if we move forward to the fact that Your Honor has already pointed out the fact that he was unregistered, without accountability for 8 different years. And this county chooses to let him off of a charge from 23, where he should have been held accountable because he received a 3-year sentence in Madison.
Which county let him off?
Jefferson County dismissed a charge in 23 DCCR 1030, and it was for his failure to register, just like we're dealing with here. As the officer points out that dealt with this charge, he is a habitual offender. He's had those convictions there, and then we're dealing with this other charge. So my comment about where the state landed on this with a 5-year cap, in my opinion, is pretty light compared to what we're looking at here. I would ask that you follow the plea bargaining agreement and sentence him to 5 years.
Okay, defense.
Judge, as previously stated, he has his support system here. He has job opportunities for probation. He has a wife and spousal support in that form. He has admitted responsibility here today. He knows the mistakes that he's made, and I don't believe that he's likely to make those mistakes again. Though it was a troublesome journey getting to this point. I think that given the chance to show the rehabilitation, he would be successful at that.
Judge, I neglected to mention that at the time in which this offense occurred, he was listed as living with his mother. So his family support was available during the time frame that he committed that offense. I don't see anything different with what he's suggesting to you today. That address that's alleged here, that the detective refers as his mother's address.
The Lee Street.
Yes, sir.
Okay. Anything in response on that? Because that's a good, I think the state's got a good point there. I mean, he's. This is on March 9th, last year. He's still playing hide and seek from us. He's not being held, he's not being accountable when he had an opportunity to, and he knew that he was surrounded and the trap was getting tighter. It would have been nice for him to come forth and show some contriteness and accept responsibility. Yeah, we're talking about the underlying, not to lose track of what we're talking about here, but I can't feel sorry for a child pornographer. Every image of a child is a victimization, every image. Can't imagine how many separate victimizations you were part of in all of these convictions, which or I'm adding one. I think 12, 13, 14 misdemeanor and felony convictions total. Okay. And then this failing to comply with sex offender registration is very important so that the authorities can monitor someone, because we all know sex offenses have a tendency to repeat if the monitoring and supervision is not strict, like what we're showing here. What are you asking for?
I'm asking for him to have a chance on straight probation, Judge.
And great lady, she's works hard for her clients. She can't produce something that doesn't exist, though. She has to have something to work with. How many probations have you been on that you failed and were revoked on?
If I am mistaken, I believe my DUI convictions were successfully completed.
Talking about,
Felony level offenses, Judge?
yeah,
Would just be the ones from Florida. There's
Mhm.
several different counts,
Six
but they
of
were
them.
all
6. Okay. And just to correct at least one, this 98 Brazos County DWI, you were on probation, that was revoked and you received 75 days in jail on that. So you do have a misdemeanor revocation, but I'm looking at 1, 2, 3, 4, 5, 6 revocations of probation when you were placed on probation out of Collier County, Florida, for electronic transmittal of child pornography in each of those cases. And then you're sentenced to 5 years probation, 5 years imprisonment on those, correct? Altogether. Yeah. And just one last question here. what is your explanation for on March 9th, 2024, when the officers show up at this address after locating you? You had had a decade of committing the crime, of failing. Every day was a crime of failing to register. So a decade, but you know they were there and you still did not turn yourself in until later, right? I wish you would have had a change of heart earlier until when you knew that the trap had been shut and it was just a matter of time. But I wish you would have made better choices. But I also wish that each of these children who were victimized in this very widespread child pornography crime spree you were in, I just wish they wouldn't have been victimized. I feel sorry for them. Anything else?
All I can say is I am going to go forward, no matter what happens. I am going to go forward and do the right thing.
Never too late.
Never too late, sir. And I do plan on complying in every manner and facet.
If you don't, it's a crime.
Yes, sir.
Again.
Yes, sir.
Nothing further. I'm going to find you have pleaded guilty to this third-degree felony of failing to comply with sex offender registration requirements. You have pleaded guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea. From State's Exhibit 1 admitted into your plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. And you're not serving, you don't have any other cases that you must serve sentences for, do you? Have you served out all those others as far as you know?
Yes, sir.
Because you were sentenced to 5 years in prison on all these Florida cases that ran concurrently.
Yes, all that was already served. Yes,
okay. And you are currently registered properly under the sex offender program?
Yes, sir. And I'm at the halfway house in Beaumont.
All right. Okay, then that is the judgment of this court. The court finds under these circumstances, this is fair and just. And you were taken into custody to serve to complete this sentence and do better on all of this from here on. That is all. Thank you. Y'all have, let me get yours and then we'll get back to Reagan. Thank you. This goes into Mr. Ramirez's file. Thanks. Thank you. Who's this? I'm sorry. One currently. There it is.
Okay, then you're gonna place it flat in the box. Right here. Yes, ma'am. Ink it up one more time. We're gonna do like just a copy of it. Next to it. There you go.
Why aren't you up here? You're doing all the heavy lifting in all these cases.
Yeah,
You're doing all the heavy lifting.
That's gonna make sure you just go. Yeah.
Oh, good work. It's Eat Cow's your sponsor.
Yeah, but the computer.
All right, we now call cause number 22-39869, the state of Texas versus LaJuan Kirk. You're Ms. Kirk?
Yes, sir.
All right. Present with Mr. Walker, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
She does.
In summary, ma'am, this indictment alleges that from on or about November 1st, 2020, and continuing until on or about February 28th, 2022 in Jefferson County, Texas, the states you committed a third-degree felony of theft of a value of $30,000 or more, but less than $150,000. Do you understand what you are charged with here?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached where you would be pleading guilty, sentenced to 5 years in prison. That confinement would be suspended. You would be placed on the regular probation for up to 10 years in length. There is no fine, but restitution is owed in the amount of $25,000. And there would be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, ma'am? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, and because you are guilty of what the indictment alleges in this case? I show you what's marked as State's Exhibit 1. Did you sign that document? Did you understand its contents? Discuss it with your attorney. Are the contents all true and correct here?
Yes.
State's Exhibit 1 is tendered into evidence and without objection.
No objection.
Admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1 is part of the record without objection. And pre-sentence report waived here?
Yes, sir.
Well, let me ask you, this is a lot of restitution. How is that going to be paid back? Over what, how much are you able to pay so that and I believe it's going to be going to the complainant in this case?
Yes.
How?
It's a doctor's office that
It's
you
a
work for, yeah.
Mhm.
I don't know yet. I have to do it. Everybody has whatever I'm told.
Because I'm going to follow the agreement and place you on this probation. But, you know, this court's practice has always been when there's restitution, the quicker it's made, the quicker the person is released from the probation.
Yep.
So it's a win-win for the victim and you.
Yes.
But I'm just curious what we're looking at. You think it's going to take the full term, maybe?
Judge, I don't think that's going to be the case. Her daughter's here, have been with her every single time.
Y'all have a plan that maybe the family's working on getting this, because once again, this, I reward the completion of restitution. They get every time. I want the victim taken care of, and that's how you purge the sin, as it were, and move on with your life. And then they can get repaid as they always lose the interest on it, when it takes time. But still, it's the way to fix it the best that can be fixed. All right. So I find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. That will be suspended. That confinement suspended. You were placed on regular probation for 10 years in order to pay restitution to the complainant in this indictment in the amount of $25,000. There will be other terms and conditions of probation that the probation officer will work with you on. And once again, I can't emphasize enough. This court can terminate probation in a third of the time, 3 1/3 years, as early as 3 1/3 years for 10 years. But it's conditioned on the expedient repayment of restitution to the victim. That's going to be the key. And that gets you out of this. That stops the probation. And when that can happen. And it gets the people paid back. Win-win. Just to a degree. Thank you. And thanks for helping on this, ma'am, on the family. And I know that everybody would like to see everybody move on as quick as possible with their lives again. Good luck. Please see the probation officer. Thank you.
Thank you.
Yes, thank you, sir. Best wishes to the family, Glenn. Of course. I'll take care of the guy.
Yes, sir.
Back to Reagan. I've got Monica Ritchie.
Hey, Judge. I need her to swear me.
Come on in, up, Miss Ritchie. Thank you.
How did this spell? Ms. Ritchie? Okay. Would you raise your right hand, swear or affirm to tell the truth, the whole truth, and nothing but the truth yourself about the same. Okay, you have the right hand raised. Place it flat with this. Now that one more time, I need a little bit darker at the end.
In clause number 24 CR 1999 Damian Walls. There is a motion to dismiss before the court.
Yes, Judge, he had 3 cases. We pled to 2 of them and dismissed the third.
No objection to this being done now. Correct?
No.
Thank you. That case is dismissed.
Flat right there, but no, don't roll it. Yeah, just speak to that. That was because I'm gonna see it, so it's just be flat. Well.
But those others haven't been, those others aren't disposed of yet, right?
Not yet, Judge.
Oh, okay. Well,
They should be on the
I
tablet.
jumped on that early to. Okay, you are just Ritchie?
Yes, sir.
Yes, ma'am. I'll go over this one again.
Right.
One case. Oh,
That's correct, Judge. Yes, Judge.
25 CR 203 is now called the state of Texas versus Monica Marie Ritchie. That's you?
Yes.
If Ms. Minaldi, your attorney and the state's attorney does, the defendant waive a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about July 5th, 2023 in Jefferson County, Texas, you committed the state jail felony of driving while intoxicated with a child under 15 years of age. Do you understand what you're charged with here?
Yes, sir.
It's a state jail felony, which means if convicted, you face no less than 180 days up to 2 years in state jail. And the fine up to $10,000 can be assessed. Is that your understanding of the punishment range? An agreement's been reached where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, fined $500. And there would be other terms and conditions of probation, which include replace interlock requirement with drug patch. That's what everybody agrees to?
Yes, sir.
Shall we? And semicolon, added conditions relating to substance abuse. All right, tell me what y'all's plan is on that.
Okay, I spoke with liaison from probation department and just asked for what essentially was available to help treat substance abuse. What did you say, James? JCBI has been added as part of the probation conditions, and then she will still be subject to the routine drug testing.
Tell me what happened in this blood test. What was the result? Because I don't have it. Hold on. Where's 9925? This was a recent test we did, didn't we? She tested positive in
Yes,
September.
for things that she was on the prescription for, but in her toxicology results that came back pertaining to this case, she tested positive for methamphetamines and had amphetamines in her system as well, which was the basis of the DWI here. Her prescription medication was not. the
Okay,
basis.
and that's the basis why we are replacing the interlock requirement, which is the problem is not alcohol,
That's correct.
but it's controlled substances,
That's correct.
which we try to police with other methods such as drug patch.
That's correct.
Okay. That's a plan. Is that your understanding?
Yes, sir.
If I follow this plan, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Let me show you what's marked here. States Exhibit 1. Did you sign that document voluntarily?
Yes.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
States Exhibit 1 tendered
No.
into evidence and without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. It states, so help you God. States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I will follow this agreement and find that you are mentally competent to enter into this agreement. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement will be suspended, will be placed on regular probation for 5 years. There will be terms and conditions of probation, which are not only normal and customary for this type of offense, but also special for these circumstances. You will be fined $500. You will be required to have a drug patch until otherwise ordered, and that will be tested regularly. What else do we? Yeah, I'm sorry. And Jefferson County Drug Interdiction Intervention Program, which is a good program. You will be required to attend and successfully complete that program as supervised by the probation office. There are a lot of probation conditions, but you don't get intimidated. Most of these, all of us have to follow.
Yes, sir.
It's kind of like there's some folks who we have to start from scratch, and that's why this are all basic. A lot of these are basic conditions of good behavior and proper lifestyle that we are used to. But then they have other, don't associate with disreputable people, commit no crimes. I mean, all of those are things I got to do and all of us should do. But there are others that are going to be special for your situation. Make sure you follow them. If you fail, you don't want to see failure, but if you do, your probation could be revoked and you'd be sentenced up to 2 years here in the state jail, which you don't want, because it's almost all 2 years. Because parole is kind of different than state.
Yes.
Ironically, it's more strict than higher felonies as far as the the rewarding of them. Got writer's cramps on this stage, yes, ma'am. All right, do you understand what's happened today, ma'am?
Yes, sir.
All right. And there's not, because of the nature of this, there's not a mandatory jail requirement on this
No.
crime because we're not talking about a alcohol related offense here.
Well, we're talking
right?
about state jail felony level, judge, and that does not require any
Yeah,
upfront time.
it's not. Ironic. That's an interesting thing too under the law, but it has reasons for it. Anything else to add here?
No, judge.
Are you going to do well?
Yes, sir.
Good, good. Keep your promise. Okay, please see the probation officers. Thank you. Next, who's next?
Kishan Thomas.
Keyshawn Thomas. That's not a plea.
No, he's not.
Is it just one?
Just one.
Shouldn't have done that.
25 CR 630 is called. You are Keyshawn Thomas.
Yes, sir.
And you are here with Ms. McNally, your attorney and the state's attorney. You were charged in this case with the state jail felony of evading arrest or detention. And it says with previous conviction. Boy, do we have that. How many prior convictions do you have,
I'm not three.
sir?
Three.
Wrong. I should not know more about your life and convictions of law violations than you do. But I'm looking at, let's see, 2009 in this court, illegal possession of a controlled substance, a state jail felony. 2013, 252nd next door, unlawful delivery of simulated controlled substance. Also in the 252nd, it looks like a delivery of a controlled substance on August 5th of 2013. Also on August 5th, 2013, next door, delivery of a controlled substance and a fourth delivery of a controlled substance. Those are all separate crimes. So that's 1, 2, 3, 4, 5 convictions, plus not counting the evading arrest in 2013 and the other evading arrest also in August of 2013 out of the 252nd District Court, which resulted in this case being a state jail felony rather than a lesser offense. So you, with all of this, I mean, you could be looking at a state jail felony punished as though it were a second degree felony. Well, we've got, let's see, 2013, 13. They're all in 13.
Yes, but.
No, I'm
there's-
sorry. There's 2000.
The prior,
Nine.
they're all state jail
They're
felonies.
state jail felonies and they don't require. it.
Yeah.
So if you have more than, you have two
So
from state jails,
You were looking at
then it's
up-
third degree.
up to
felony.
10 years in prison here, but what are we doing? From Mr. Thomas.
Judge,
Oh, there's not a plea on this. Oh, okay. So you got a lot here that you got to work out,
Yes.
correct? And the most important thing is this is the third charge of evading arrest, right? Okay. Okay, go ahead.
We do have an offer, Judge. I need a meeting with him at the office that I
How
can.
much time do you need?
4 weeks.
You got it?
Thank you.
Okay, thank you. Get a resetting, Mr.
Highlighted extra.
Let me ask before he leaves, just have a seat right over here, sir, in the jury box. Okay. Who's next? Reagan, you have,
That's all for me, Judge.
that's it. Giles, I see you got Melissa Bell. Yeah. Yes, sir. Is she here? There she's doing. Okay, we call 25 CR 31, the state of Texas versus Melissa M. Bell. There we go. Thank you. And it's Melissa M. Bell. What's the M stand for in the middle? Uh-huh. And you were here with your attorney, Mr. Cole, and the state's attorney. And does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary? In summary, ma'am, this indictment, which was handed up January 15th of this year, it alleges that on or about January 3rd of 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
Yes.
And this is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand the punishment range for this type of offense?
Yeah.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length. I see a non-binding recommendation is for 5 years. But what I normally do is assess the most up to 10 years, but I reward. You can get this dismissed in 1/3, 3 1/3 years, which is that's the way I do it here. I reward people, and I think you get a better reward having it this way. But there would be terms and conditions of probation, which are normal and customary for this type of offense. If you would not be found guilty, but if you failed to perform properly on probation, your probation could be revoked. You could be then found guilty and sentenced up to the full range of punishment, up to 20 years imprisonment. So there's a lot riding on success and a lot on failure. You don't want failure. This is fixable, right? This isn't going to ever happen again. Anything like, look, I believe you. If I follow this agreement, you have no right of appeal. Do you understand? How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty. I'm going to show you here what's marked as State's Exhibit 1. And I'm going to ask you if you signed this document, discussed it with Mr. Cole. Is everything true and correct? State's Exhibit 1 is tendered into evidence.
No objections.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are given up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all who so help you God. State's Exhibit 1, part of the record for all purposes. Anybody want to add anything before I make findings?
Shannon,
Go ahead.
Miss Bell, her son is coming out of here in about 2 months. I don't think she's ever been in any trouble. She's, like you just said, this will be a one-time incident, isolated incident in her life. She's ready to move on. And she acknowledges that she made poor decisions at that. So I think she would probably have 5-year probation since she put on.
There was no other criminal history, Your Honor. We did agree to the non-binding. Obviously, it's up to the court to
What do you think? He's
we're not opposed, Your Honor. Obviously, it's your decision. Based on there's no other criminal history here.
Judge will leave.
I don't think so. The odor of alcoholic beverage from the breath. So sometimes that makes inebriation makes you make bad decisions in a crisis. All right. I'm going to find there is sufficient evidence supporting this guilty plea to find you guilty beyond a reasonable doubt, but I'm going to place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normally customary for this type of offense. Among other issues, we're going to place you under an anger management program, but also we also need to, there will be some conditions here to check for screening for any kind of inebriating substances that you might take in, because it's obvious that when that happens, you you can make a poor choice, and we don't want that to happen. We want you to be successful. We have a 93% success rate on probation. We're very proud of that. Don't let us down. All right. Please see her. Thank you. Good luck.
Yes, thank
you. See you, Josh. Sure. Yes. Okay, I've got Damian Walls. Who's on that one?
That's John West,
John West.
and he's something for him.
Damian Walls. Where's Damian?
I hear.
Damian, come on up. Oh, you got another one?
No, sir. I think that's it, yeah.
Okay. Hasta luego. Yes, sir.
Mr. Walls.
I'm learning Spanish.
Where-
Guys.
You have your right hand front? That's that right there? Oh, I need it.
Is he pleading to both?
There's two, Your Honor, and one of them's dismissed. You signed this last one.
I know I did, but I've got two others in the.
Yes, it's
Yes.
pleaded to
Also.
Please and one.
two, third, and then dismissed the third.
Mr. Wall.
Sign right.
I think. 48 and 43. Okay, 99 has already been dismissed. The third.
Yes, Judge.
Two cases are now called. 24 CR 2238, which is credit or debit card abuse, and 24 CR 2343 theft. More than 2,500, but less than $30,000. Each of these are state jail felonies, and these are indictments styled the state of Texas versus Damian Walls. You're Mr. Walls.
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. Does the defendant, Mr. West, waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, Your Honor.
And in summary, the 2238 credit or debit card abuse allegation states that on or about August 5th, 2024 in Jefferson County, Texas, you committed the state jail felony, intentionally and knowingly using a bank credit card, knowing that it was without the consent of the rightful card holder. Do you understand what you're charged with there?
Yes, sir.
And in 2343, this states that you committed theft of furniture of the value of $2,500 or more, but less than $30,000 without the consent of the owner of the property. And that is also a state jail felony. Each of these cases, you, if convicted, are facing a term of confinement in the state jail for not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
When are we going to get new pads?
They've been ordered, Judge. I
Oh, these things are just, you need to know.
can't do much more than that.
Takes longer to correct all the pad misworkings on the electronics here. The same agreements in each case?
Yes, Your Honor. Yes.
The only difference is one has restitution and one does not.
Right. Okay. It looks like in each of these cases, you're going to be pleading guilty.
Yes.
And found guilty, sentenced to 2 years in the state jail on each case, and that would be suspended. That confinement would be suspended. You would be placed on regular probation for 5 years on each case. And there's going to be, it looks like restitution will probably be owed
That case.
in the
The restitution is in,
2343 case,
yes, Your Honor.
and that is in the amount of how much?
3,000, let me give you the exact number here.
$3,130.59.
Is that true, sir? Is that your understanding of the plan in each of
Yes.
these cases? If I
Yes.
follow these agreements, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead in each of these cases, guilty or not guilty?
Guilty.
You're pleading guilty voluntarily
Yes.
and because you were guilty.
Yes, sir.
And also in just particularity in 2343, this alleges, again, you committed the offense on or about August 11th, 2024, the state jail felony of theft. I can hear all that.
Gracious.
Okay. And in 24 CR 2343, you will have terms and conditions of probation, which are normal and customary for theft, and restitution is to be paid in the amount of $3,130.57. Is that right, everybody? To the complainant in this indictment in cause number 24 CR 2343.
Yes.
Correct, everybody?
That's just.
I think it's 59 cents, not 57, just for clarification.
Yeah, the 7
purposes.
didn't. This, it looks like a 7, not a 9. Let me make it a 9. Let me erase it and start over. Okay. $3,130.59. How long would it take you to pay all that back? A little at a time, I guess.
Yeah.
How much can you pay back monthly? Because the quicker this person gets paid back and you do well on probation, the quicker these probations end. If you know what I mean, I reward. I do in most cases.
I don't know.
Like $150. Can you do 150?
Yeah, I'll find 200.
You don't stretch yourself. You could do 200 a month. That's
To get it.
toward restitution. There will be other fees too you're going to have to pay.
And he's already on probation out of Harris County right now as well. That's running.
They have these other probation fees and they kind of nickel and dime it.
Yeah.
But is 200 going to be a stretch?
150.
Just
150. All right. All right. Thank you. All right. If I follow these agreements, you have no right of appeal. In each of these cases, how do you plead, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty in each of these cases?
Yes.
Okay, and I already show you.
No, not yet.
States Exhibit 1. Hold on. Let's
Yeah.
scroll it back.
Bad, I can't. It's not probably code touching. They're not supposed to be touch bad, but they seem to be.
Yeah, you can start a missile off or something.
Okay.
You sign these documents?
Yes, sir.
Voluntarily, discuss them with your attorney. Everything is true and correct. States Exhibit 1 tendered into evidence without objection.
No
In each of these cases, it's admitted. In each of these cases, States Exhibit 1 states you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged of any lesser included offenses. You were giving up your rights to a jury trial. The rights to your appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God in each case.
Yes.
States Exhibit 1, part of the record. In each case, pre-sentence reports are waived.
Yes, please.
I will follow these agreements. And I will find in each of these two cases, sir, 24 CR 2238, credit and debit card abuse, and 24 CR 2343, theft, state jail felony theft. You have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt in each of these state jail felonies. I am following these agreements. You are hereby sentenced to this state jail for confinement for 2 years. That will be suspended. You are placed on regular probation for 5 years in each case. There will be terms and conditions of probation, normal and customary to these types of offenses. In the theft, 2343, you must pay restitution in the amount of $3,130.59 to the complainant listed in the indictment, and you must pay restitution a minimal amount of $150 per month. There will be terms and conditions of probation. The probation officer will go over with you. Make sure you follow these.
Yes.
If you fail, your probation could be revoked and you could be sentenced up to 2 years in the state jail on each case. We don't want that. To fix it, move on with your life, do well.
Yes.
There's one. Here it is. Thank you. Here, we've dismissed the other. On Etta Stelly, Etta Stelly, Tom Burbank was your attorney, correct?
And Mr. Burke is running late. He's stuck in another court.
You think? Okay, stand by. He's supposed to be here shortly. Thank you. Christopher Clinton and Sabrina Gallagher and Tammy LeBlanc and Kevin Ramirez are all Mr. Gertzis. And then Charlie and Brent round out the field. Okay, y'all don't have to come up here at one time. Let me take one at a time. You are who?
Christopher Clinton.
Okay,
Judge, this is the case that is still, I'm just reminding you. I know.
I slept yesterday.
I know, I mean, that's why I got my reminder for here. This is the case where we're disputing with DPS
what do
whether,
we want to do today?
we just need to reset.
How much?
for,
When is this all gonna get, you think?
Judge, it's up to the court in Austin. So
Here, review and what?
90 days, is that too far?
Yeah, listen, how about
6
six weeks?
6 weeks.
Just to make sure everything was, we're
Okay.
still touching base with each other. Okay, it reset or review from Austin on some other matters. Sabrina Gallagher.
Judge, we've got a,
Sabrina Gallagher, this is 22-41053.
we're asking for a short resetting on this, maybe 2 weeks. I got a new offer from Ms. Gasper this morning that involves some discussion that we need to have regarding restitution. That's what we're working on.
2 weeks.
2 weeks of this.
Okay, reset 2 weeks, please. Thank you.
Reset. That's good.
Tammy LeBlanc.
Judge, could we just get one more announcement on this, maybe 6 weeks?
How long is that?
It's relevant.
Okay, you're Miss LeBlanc. Yes.
Maybe we have another announcement on this.
How much?
6 weeks, ideally.
That ought to do it. 6. Okay. Please get a resetting. Thank you. Kevin Joe Ramirez.
Someone highlighted that for me.
And we've got, who's the prosecutor on this? Because I think this was a replacement. On Kevin Joe Ramirez. What are you doing here?
Judge, I need to discuss an offer that Mr. Ham extended to me. But I think our inclination is going to be to put it on the trial docket. I don't know if you want to reset it one more time for an announcement.
You've run out of resettings today.
Okay.
Yeah, you exhausted.
Let's go to trial.
That was, you exhausted. We'll see you in about an hour.
Yes, Judge, we're ready. So,
Okay, we do have a jury coming in for you.
oh, I appreciate it.
What are we talking about, like a date of this? What?
I think we need to discuss it with Mr. Ramirez, the offer that was made to us, but I anticipate it's going to result in putting it on trial. So happy to do another announcement, or we can just go ahead and put it on the trial.
Okay. Mr. Ham, you just put it on the trial docket? That's what they're saying? Is that what you want? Okay, we'll set it on the trial docket. And that's all he's charged with is that, right?
Yes, Judge.
.183 was what the result was, it's showing. You don't happen to know the victim in this case, do you?
No,
You didn't, okay.
Thanks, Judge.
Sometimes weird things happen with them. That is all.
What did that do?
Hey, Sean,
Yes, sir.
Thomas, let's get you. Here's-
He got his reset already.
He's got his reset. Still a Wago.
Thank you, Lance.
You're free to go. He's free to go.
Oh,
He's clear as a
oh,
whistle.
Mr. Ramirez,
Oh, does he need that?
there's your call.
Oh, you. I've got Medina. David Medina, Charlie. 24 CR 133A. Status. This is what this says, status.
I think we're close to it. If I get one with the reset, I'll finish going over all the scope with them. I think we're gonna come back next time and be able to make a decision.
It's over a year old.
Yes, it's over a year old. I've had it for like 3 months. I've only had it for 3 months. But I think we're, next time around, I think we'll be.
Is 4 weeks good? That's,
Plenty.
I'm gonna give you just 4. Okay, thank you. The other resetting. Robbie, I'm sorry, Jacarius Francois?
Medina, it's not on the highlighted X for me.
Mr. Gonzalez wants to go to trial judge.
Okay.
Move it to the trial docket. I can't go back to the trial.
Okay, who's on this one for the state, please? Francois? Okay, there's, the prosecutor is blank on this. I guess it was for somebody else who.
They're good. It changes in prosecutors lately.
Yours?
Okay. You're from my bucket.
It makes sure when I haven't tripped over your pocket too.
And I had to stay happy heart. I apologize. Look. I think it might be that I'm gonna be ready to travel and pick. Doesn't really. Yeah, I felt like motion time in that good mind for home. But which is not. No.
All right. This is disturbing. Have you had a chance to look at this? So I guess.
Oh, yes, sir.
Prosecutor was on it.
This has been on the trial docket multiple times with Mr. Macon as his lawyer. Familiar with the facts and circumstances. I agree with you. It's disturbing. If he wants a trial, let's give it to him as soon as possible.
Well, whenever defendants in this particular type of case are anxious to go to trial, there's something amiss.
I'll prove it up without her if she's not available.
Because I'm looking at this probable cause affidavit, and of course, do you have anything to show that he has attempted to contact her or anyone on his behalf?
I have not heard.
Because if I find out, you will be put in jail without a bond. You understand? Because I don't want the victims being influenced and threatened or made to feel guilty, because I'm looking at this probable cause affidavit and you'd be doing that. I wouldn't be surprised if you get caught, because I'm looking at what you did here. And this is most disturbing, and I think a jury would find it most disturbing. When was the last time you ever contacted this person or had someone on your behalf contact the victim here?
Years, basically.
This child that she was pregnant with, didn't, what does, just know anything about?
He's actually told the court previously that the child was born and he recognized that it's his.
Was the child fine? Because
Yes, sir.
this assault allegedly,
Yeah,
was,
despite his actions,
could
the
have-
child was helping.
and then according to this, this probable cause affidavit, he was calling the victim threatening to commit suicide after this arrest.
That's correct, Jeff. That's part of his admissions to court, the defense, excuse me, I'll use in the trial.
Fine.
That's why the state's going to move forward whether she's present or not.
Okay. So, when can y'all be ready? Because this thing is long overdue. Whenever you rent,
I guess a natural resetting.
there is nothing normal in this courtroom.
Say normal.
Basketball. What are we setting cases on right now?
January.
The state's had this case ready before, Judge, so whenever you want to set it, I'll have it ready again.
Set it the first week of January. I have.
Anything sooner?
I mean, I could set it on something in case something falls through. We just keep resetting it. That's our options.
Judge also realizes this is an old case, but this is a transitional case for you.
And I'm not going to set it next week, but
I think we have a
but
relatively
maybe
smaller
that-
docket on November 17th, if we can place it on that.
It is a smaller docket that's, will be in the,
Fair, ma'am.
will be in the different courtroom that week of the visiting judge. So we do a smaller docket.
Okay, we'll reset this for potential setting on, y'all try to be ready on November 17th. Okay? All right, thank you. Curious. Robbie Kelly?
You need to sign on the highlighted X for me.
Judge, on this one, Mr. Kelly and I met this morning initially because he'd been on a bond. I didn't have the contact information, but he's telling me he has not yet seen the discovery. I guess it wasn't shared with him previously today. He was not aware of the details of his charges. And so
Why not? I mean, this was indicted in January.
I know that he's
10 months ago,
he's
10
been in
months ago.
rehab for a large portion of his years, but
Since April 1st, I've been sober living.
my understanding is he's been out of contact, like no phones, no, I guess no.
But in the beginning, we had a blackout period. Records in all my. All of that.
And I
Well, it's,
You gotta have a wheelchair back in face wheelchair.
you've got a copy of the probable cause affidavit?
I do.
Okay, all right.
Yeah, so I got.
It looks like it's not a lot of,
No,
I don't think there's a lot to it. There's fingerprint evidence and other information about what damage was done in the commission of the burglary, and that looks like it's straightforward, so. Anyway, we'll set it for trial.
Okay.
All right, as soon as we can get it placed, thanks. I've got.
I'm here, sir.
Sorry. Yes, Etta Stelly, come on up. Okay. You were Ed Estelli? Okay, you were charged with the second degree felony of collision of a motor vehicle causing the death of an individual. So this means if convicted, you were looking at up to 20 years in prison. Serious. So
Yeah.
Thomas, Mr. Burbank is your attorney?
Yes.
I'm gonna have, he's, I don't know where he is, and we're 2 hours into the docket, and we're gonna have to reset this. When can we make a resetting here? Next week?
That's fine.
1 week? Sorry, ma'am. I can't get anything done without the lawyer here.
He said.
All right.
And Judge Urban also had a Misty Green.
I don't have any files.
They're right here, Judge. She's from the initial docket. Here you go. Tell me to hold off on it.
Misty Green. That, where are you?
She's hard.
Okay.
I highlighted X.
Mr. Dusler is your attorney.
Mr.
Burbank is hired, Judge.
Yes, she hired Mr. Burbank.
Where is that shown? Let me make sure you got something.
I looked in the electronic file, Judge. We just received it
Just
yesterday.
in? Is that right? You just hired? Okay. All right, well, let's reset this next week for an initial appearance then. Or an appearance with our attorney. The quicker I get this finalized and he's here and working with you, the quicker y'all need to move forward. Because in these two cases, I don't have to tell you, one is up to life imprisonment and the other is up to 20 years in prison. So these are most serious, and the quicker your attorney is working with you, the better off I feel for you to be properly represented. Okay. So I'm just going to do 1 week. All right, please get a reset. Thank you. I think that's it, right? Anybody else supposed to be here?
Just highlighted X form.
Get a call? Who's this?
You took into custody prior to you, get a disposition from.
Okay, your name?
You said her. Sorry.
Come on in.
She had an active warrant for her arrest.
Oh,
Yeah, and then we just resolved the case.
okay, but she's in custody because there's an
Because
active
we're
warrant.
active.
Okay, and we've reset your case, so you're free to go with the officers. Thank you. Good luck. Anything else? We'll reset till this afternoon, correct? What is it, 1:30? 1?
Form, is that correct?
Yes,
Any question regarding any of those rights?
not this time.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
and of your own free will.
yes,
I have been provided and have reviewed Ann Arbor Police Department report for their case number 25-31-672. Any objection to the court having reviewed that report?
no, no from the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, I should say, and you would not be permitted to withdraw your plea. You understand that, sir?
Yes,
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
no, no, Judge.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 4th at 9 a.m.
November 4th, 2025, 9 a.m. That is before Judge Valvo. Bond will.
If I could be heard on bond, Judge.
Sure.
Your Honor, Mr. Kelly is here on he's a 5,010% bond. He has resolved the felony matter. He has taken responsibility in this matter. His mother has been in court with him every single time, and she's in the front row here. She says that he is welcome to stay with her while he's out for sentencing, and we'd ask the court to grant him a personal recognizance bond, and with any conditions. I think he'd welcome any conditions that would ensure the safety of the public, up to including potential tether and no going to Target. This is an event that happened. Well, you read the police report, you know.
Yeah. Well, I'm concerned about why it entirely happened from his perspective. I guess maybe I'll ask it a more direct way. Are there CMH issues?
Yes, Your Honor. He has there are CMH issues. He has an alternative treatment order. He has received a shot. I believe he's just received it not too long ago. Is that correct? Yes. When was the last time you had one? I can't remember. But I don't think he'll be due for another shot before he's sentenced. Is my understanding. Don't quote me, but last time he and I spoke, he had just gotten it, and this matter was set for an exam.
Is this right? Is this his only case?
I don't believe there's anything else holding him, Judge. No.
Okay.
That's what it looks like.
And
I think it's 5,010%.
right, and the treatment plan is through probate court, I presume.
Yes, I believe so. If I could just have 1 second, Judge, I have my notes in the.
Well, I guess the other thing I want to know is, was he on the treatment plan prior to this event?
If not prior, Judge, I believe that the two may have coincided.
Well, I get, okay, so here's what I'm trying to figure out. If he's on the plan prior to this event, and then after this event, he then gets onto the plan, that's one thing in my mind. If, however, he's on the plan prior to, maybe not cooperative with that, and then this happens, that's a different issue for me.
Your Honor, he reports that he's just been receiving the shot for the last month.
Okay.
It would have been after the plan. This precedes the shot here.
What I will do is, I'm not gonna give a PR, but what I would indicate is that, I will reduce his bond to a 1,010% bond. I really would prefer that Judge Valvo, since she has it, take a look at it, given her history with the mental health court. Take a look at it. I'll reduce it to the 1,010% bond. I will also indicate prior to his place on the GPS home confinement tether.
And I will get that address to the court, Judge.
All right, very good.
Thank you.
Thank you.
Mr. Goldstein is going to give us the phone as soon as his clients.
Got it. It's a guilty.
Yes, sir.
To a misdemeanor, I'm presuming. Does call the case of the people versus, is it Antoine Pitts?
Water Assistant Prosecuting Attorney on behalf of the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I have the plea agreement and the license rights as soon as he signs them. All right, okay. Attorney, just sign right there. And 14. Okay, and this is the advice of rights form. You've been over this before. Right? You first need to sign it right there.
Plea form that has been.
Ohio versus Jeffrey Beebe. Mr. Beebe is before the court with his counsel, Mr. Kirby. Ms. Hyatt, on behalf of the state of Ohio, we're here for sentencing. Ms. Hyatt, anything on behalf of the state?
Yes, Your Honor. For the record, the victim in this case, Brittany Miller, is present, would like to make a brief statement to the court.
Okay.
My name is Brittany Miller, and I am the victim in this case. I wanted to be here today to share how this has affected me. I thought I could trust Jeff. I have known him since I was 15 years old. I am his daughter's best friend. That day when I asked him for a ride, I never would have ever believed he could have hurt me and that we would end up here today. It took me a long time to process what happened and why. I blamed myself for a very long time. I couldn't leave the house without having anxiety. I stopped trusting people completely. I was depressed for a long time, and it affected my kids seeing me that way. I still have so many unanswered questions about what fully happened to me that day. But I do know I was so extremely violated. I have finally, though, realized that this was not my fault. This was his fault. He is here today because of his own actions. Not only did he hurt me that day, but he hurt his family. He hurt his daughter, Kristen. I do not believe he has any remorse for what he did or even believes what he did was wrong. He deserves to be here today, and I deserve to move forward and to feel safe again. Thank you.
Thank you. Ms. Hyatt, is there anything else?
Your Honor, I know this is an agreed statement, but I just wanted to just point out in front of the defendant that, I mean, he was, the victim in this case, Brittany has known him. He was her good friend's dad, and she's known him since she was 16 years old. And back in January of this year, he did the unthinkable and betrayed her in ways that are just, are obviously horrific for her. He took advantage of her. She had been drinking prior that night before with his daughter even, and then wound up getting her even more intoxicated at his girlfriend's house, and then taking advantage by performing cunnilingus on her when she was passed out and woke up during that action. The defendant then denied having any sexual contact with her, yet texted her completely the opposite about how he, liked her taste and all that. And then his DNA was found in the pubic hair combings in the same kit, which would have been consistent with the cunnilingus act. So it's just, this is a reason why we were working this case out, which is true, to the agreed 36 months in prison. But I just wanted the defendant to know that this is not something that is an action that she's going to easily get past. And I hope that he has ways to figure his life out. Oh, and there's 122 days of jail time credit.
It was discussed with you prior to him entering a plea as far as this recommended sentence. Is that correct? And you consented to this? All right. Anything else, Jack?
No, Your Honor.
Mr. Kirby?
Thank you, Your Honor. Your Honor, my client has taken responsibility for his actions. He did enter a plea of guilty
Your Honor, he has no prior sexually oriented offenses on his record. I believe that his alcohol consumption played a big role in this offense. I think it took place under circumstances that are not likely to occur again. Your Honor, we would ask this court to adopt the joint recommended sentence. We do believe that the jail time credit is 130 days. If we could have that maybe recalculated, or maybe we could compare numbers. But other than that, Judge, we just ask the court to adopt the joint recommended sentence. That's all.
Thank you. Mr. Beebe, would you please approach the podium, sir? Sir, is there anything you'd like to tell me?
No, Your Honor.
All right. The court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. I will tell you, Mr. Beebe, that you got off easy here, because had there been a trial and you were convicted of rape, you'd been going to prison a lot longer than 3 years. But the attorneys know the case better than I do, so I'm going to go along with the agreed recommended sentence. So I'm going to order you to serve 36 months in prison. You will not be considered for any judicial release. I'll wait on the jail time credit.
Your Honor, I did pull that up, and the way we figured, when he was arrested on January 16th, he was arrested for other crimes and a probation violation in Mason Court, and was serving a sentence in Warren County Jail until June 15th of this year. And which is when that was when I began the calculation. That's how I got to that. So I think that's how
I think he was indicted on June 6th.
Correct.
This year.
But if he's serving a sentence for another court, he doesn't get credit on this case for that. You only get credit on one case or the other.
When did your Mason case expire? Of June. Oh, then that's the first day. Okay, June 15th would have.
Is that what you have, Ms. Hyatt?
Yes, Your Honor.
All right, I'll give him credit for the 122 days he served. The court does find that he's indigent for the purpose of any fines, costs, or other financial sanctions. Mr. Beebe, you're also subject to a mandatory period of post-release control. So upon your release from prison, the adult parole authority will supervise you for a period of 5 years. If you violate those terms of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You have now been convicted of a sexually oriented offense as defined by the Ohio Revised Code, and you are now a Tier 3 sex offender. You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled there for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you're also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You're also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you're also required to register in person with the sheriff or other appropriate official in that other state if you've been employed for more than 3 days or an aggregate of 14 days in a calendar year. Employment includes volunteer services. You're also required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the initial date of registration, you are required to periodically verify your residence address, place of employment, and/or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence address, place of employment, and/or place of education, you shall provide written notice of that change to the sheriff with whom you've most recently registered, and to the sheriff in the county in which you intend to reside or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. You're further advised in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers, depending to registered numbers registered to or used by you to the sheriff with whom you've most recently registered. You are required to comply with all of the above described requirements for your lifetime with in-person verification every 90 days. Once you're released from jail, you'll have 3 days to register with the sheriff of the county in which you intend to reside. Now, you're also, you have the right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. Ms. Hyatt, is there anything else?
No, Your Honor, thank you.
Mr. Kirby?
No, Judge, thank you.
All right, that's all.